We are challenging the application that on the ground of
No, but you could have preferred appeal.
no, that will I will satisfy if you rush in this matter. I will say that. In this matter, we have on earlier
When did you file the writ petition?
we have filed the requisition and thereafter it was mentioned. But there is court said that no, there is no recovery notice. Let it come in the
ওটা লিস্টে দিয়ে দিন দিদি
Milord,
but this
No, all right, you keep it.
Milord,
only there is urgent. I am very urgent.
Milord,
Very well, we shall see.
Mostly in the post.
Milord, praying for inclusion.
Next week itself.
I'll try.
Please,
Sure.
thanks.
Sure.
Milord, praying for inclusion and urgent hearing of the matter. Lordship, the fact is that you
Please give the slips, write the grounds of urgency, and give. Please don't mention. I'll see to it. See that your grounds of urgency contain the grounds.
Application for restoration.
Restoration দিয়ে দিন, the application গুলো একদিন দিয়ে দেবেন। একটা কথা বলে আমরা একটা হেড করে দেব অ্যাপ্লিকেশনের হেডিং। ঠিক আছে।
My lord, in this matter, the urgency is we have challenged the
You give your grounds of urgency and give the notice. I mean slip. But mention upon notice only.
My lord, in the last date there was nowhere on the other side. That's the problem.
Give notice to the
Mr.
department.
Bhattacharya was appointed, but he is saying that he's still not appointed by the department. The court appointed him, but he has not received the appointment from the department. My lord, I have attached the order in the last date. That was the main reason.
Please inclusion, please give it. Hearing matter you can give the slip, but it is difficult with so many motions. Extension গুলো দিয়ে দিন। When is it going to expire?
End of November.
8th?
End of November.
End of November.
My lord, I have written down the ground for inclusion. It was listed, my lord. This is a peculiar matter, my lord.
You please write down the grounds and give so that we can call.
What happened? I do not have a GST account, my GST related business, but my PAN card is false that my bank account is free. I do business of masalas, and suddenly I came to know my account is freeze. I went to the bank and they said from GST portal my account is freeze. I went to the GST portal, saw some one from Chennai have fraud my PAN number. What happened, my lord? These days online buying you have to give PAN number, or for credit card you have to give PAN number.
You should have approached the police then.
No, we have then and there we have complained to police and also to the GST portal. We have write down
Anyway,
everything.
You give the slip, we shall see.
I am for the petition. This is our
Grievance address. लिखिन
no.
You are the Same order. 12813 number ta change hoga. Same order. Next. One two nine six three. Same order.
I'm for the stage.
Written by the client.
Yes.
Signatures. Same order. Same order. পিসিটা বন্ধ করিয়ে দিই। Same order. Same order.
Alright, item number 7.
Give your names. Same order. Same order. Same order.
Well, same one.
Same order.
Enter code.
Same order. Yes, same. Same.
Same.
Same. Give your names. Yes, same. Same order.
That I am appearing for the state, my lord.
Please give your slip. Same order. Yes.
I am for the state.
Yes, same. Yes, same. Same.
Madam for the state.
Yes, same. Okay, 24. Yes, same. Please give your name.
I am for the state, my lord.
25, same. Yes, same. Scooter. Same.
My lord, this is just a, for correction of two things, my lord. One is my name and the other is a section, my lord.
लिखे नहीं.
I am appearing for respondent number 8, private respondent. Before my learned senior friend starts, the difficulty is this, that we have received the service 2-3 days back. Vokalatnama required to be filed for our entering appearance. If my lord can take up this matter next week, then we all can, there are lots of private respondents.
I don't have an issue.
My lord, we mentioned the matter also because of urgency, my lord. We
It
wanted
was
to,
mentioned on Friday.
which is why, my lord.
And we received on Friday.
But item 30 challenges the same order, but I am the foreign exchequer.
It's a better for well because I'm the main person.
30 was mentioned yesterday. Somebody, you mentioned. It was submitted that it is similar to the one appearing at 29. Then should I take it up next week so that service and all is complete in the meantime, because it will serve no
My
purpose.
lord,
if
we'll
somebody-
file an affidavit of service, at least ours, my lord, service is complete. In our matter, my lord, that's the first matter, item 29. May I file the affidavit of service? My lord, I'll tell your lordships what's happened, my lord. My lord, the final finding has been issued, my lord, by the Director General of Trade Remedies or the designated authority. Now, my lord, there's 3 months' time within which, my lord, the government may notify, my lord, the recommendations which have been given. My lord, that 3 months has still some time to go. So, my lord, only thing is we are worried, my lord, that the notification should not come, my lord, while, my lord, your lordship, my lord, is, my lord, till here. So, my lord, time, my lord, in that sense, my lord, I will not stand in the way. But, my lord, the notification, my lord, they have 3 months' time. Under section 9A, my lord, Generally, they don't do it, my lord, immediately. Generally, they don't, my lord, that's, my lord.
And when was the final finding?
My lord,
rendered?
final finding is of 23rd of September 2025. My lord, they have 3 months
The writ
time,
petition was filed on 14th November.
14 November. No, no.
So we can have it next week then, because then it will be fair to them also. So
Yes,
that
my
if-
lord, we didn't want to go into the vacation bench because this will. My lord,
I appear from
my
one
lord,
of
I
the.
hear Mr. Salve's voice, my lord. I can't see him, my lord, but I hear him.
No, I've logged in, my lord. I wonder if your lordships can see and hear me.
Yes, yes, Mr. Salve, you are.
My lord, there is a full appeal on facts and law which lies to the CESTAT. And there was some doubt. They had confused themselves by saying the appeal will not be heard. Delhi High Court has directed the appeals to be heard. Your lordship can, because what happens here is after this is the period is already ended in March 24. That's the base period. You drag it out sufficiently, the previous inquiry died because the period ran out. So, my lord, all this,
No.
they can go to the tribunal, get a finding, and the government can deal with it.
Yes,
There's a
Mr.
full
Mukherjee,
appeal on facts and law.
My lord, I have,
There's
my
a
lord, it's
point
not on, no, no, my lord. Earlier periods did not run out. Reliance
yes.
withdrew, my lord, on 2 occasions.
No,
Those
we didn't
orders are
withdraw.
there
I've
on record.
explained that. Yeah.
Number 3, my lord, I have, my lord, challenged on the ground of jurisdiction and breach of principles of natural justice. And, my lord, on a matter of interpretation, where, my lord, Supreme Court has repeatedly held, my lord, that would not, my lord, on such occasions, discretion should be exercised to hear the writ petition. 4th, my lord, our High Court has held, my lord, very recently, relying on data to show, my lord, that the benches, my lord, with regard to, my lord, anti-dumping duty are not sitting regularly. In fact, I have not sat for over a year. My lord, I had argued that matter. My lord, I have the judgment which I can show your lordship. So, my lord, your lordships, my lord, I don't mind a week's adjournment, whatever. But, my lord, my learned friends free to take these points, my lord, but I'll deal with them.
But my only point is section 9C admits of no ambiguity. It says appeal lies. Please see section 9C of the
No,
tariff
no,
act.
that's true, my lord. I'm not saying that.
Then allow me a moment.
Well, let us come back.
So then
next week.
let him put it on affidavit.
No, I don't need any affidavit. Now look
Very
at
well,
9C.
very well.
Just look at the
Very well.
section.
yes.
Three Reliance Board Association.
I have
Yes.
my mark.
An appeal against the determination or review thereof.
Physical copy.
Yes.
An appeal against the determination or review thereof shall lie to the Customs, Excise and Service Appellate Tribunal constituted under 129 in respect of the existence, degree and effect of any subsidy, or we are concerned, my lord, with dumping in relation to the import of any article or the import of any article in such increased quantities under the conditions so as to cause threatening or to cause injury to domestic industry. So it's one of a full review on facts and law. And if your lordship sees under 1B of this,
Yes.
an application made before the appellate tribunal in an appeal under 1 for grant of stay or rectification or any other purpose, etc. So, my lord, they have all the powers. It is there. Now, if they are not hearing early, your lordship can direct the tribunal to hear it in 2 weeks. It's a subordinate tribunal to the High Court, my lord. But if this is an appeal on facts and law, because I tell my lord, there is a problem in this. This is a determination anterior to a legislative act of imposing a duty, which is done by notification. And there is always a period of investigation. Now, what my learned friend very skillfully says, Reliance withdrew. My lord, we had applied to the government. It was a different, one country was different, and it was for there is a period of investigation. If your lordship sees for 1 second, my lord, page 975 of the record, it's in volume 7.
Yes. 975.
Yes, my lord. Please see under the heading L.
M,
This L.
information.
My lord, and at page
Sentence beginning
97.
information.
No, the sentence
is the
beginning the
period of
period of
investigation.
investigation. Yes.
975.
975,
Yes, my lord.
volume 7.
Subpara L.
L,
Subpara L.
not M. Yes,
No,
L.
I'm so sorry, my lord.
The period of
The
investigation.
investigation for the present investigation is 1st April 2023 to 31st March 2024. The examination of trends in the context of injury is 2021, 21-2, 22, 23. Now that was for a different period and there was one different country. So my lord, it's not like we petition. We only tell the government saying, look, there is dumping going on, it's hurting us. So they fix a period, back period. They have conducted this investigation. Now this has to run its course. But these proceedings saying I'm challenging jurisdiction, I'm challenging this, I'm challenging that, first in the court and this, and in the meanwhile, they've all made representations saying all this to the Ministry of Finance, saying don't issue this notification. So all this is all, these are all forensic ploys which are put in play. If there is a full appeal to the tribunal, your lordship can direct that the tribunal will decide the appeal in 3 weeks' time. They will do it.
But Mr. Salve, Mr. Mukherjee submits that the tribunal is not regular. It might.
No, my lord, there is a full, there is
And
an
my lord, not
excess
just
tax.
that, my lord, I have
Allow
an
me one
issue,
sentence.
my lord, for there, my lord, to be an effective appeal, my lord, I ought to have been given, my lord, the data. My lord, which has
Now that's
no,
on
one
merits.
minute, my lord, my learned friend can have a say on it later. I have taken, my lord, the point of, my lord, breach of the principles of natural justice. That, my lord, itself, my lord, the Supreme Court has pronounced innumerable occasions, even if you have a statutory remedy by way of an appeal, fully on facts and, my lord, on law, my lord, the court, my lord, will exercise its discretion to hear, my lord, the issue on, because the appeal is, my lord, really meaningless. Because what do I argue on if I don't have the data? And my lord, this data was needed to be supplied to me because it's a worksheet which has been done on pricing of my products. And my lord, the Supreme Court has said on this, no confidentiality can be claimed.
My lord, this is clearly a matter which the tribunal can look at. They will have to decide the relevance of that data. Was that data critical? Did it affect their rights? This is not something, well, these are old. We all argued all this natural
this is
justice,
not old.
etc.
Well, it says new as 2025. I'll rely on those judgments.
These are old principles that breach of natural justice is a matter.
Constitution was of 1950. The principles will be old.
I thought my learned friend had allowed me a moment. Look,
it's dangerous to allow my learned friend.
The point is this. What is the relevance? Somebody comes to the court, and this is exactly why full appeal is important. The tribunal may look at the data and say, look, this meant nothing, or this is not being relied upon. Before the writ court, you are saying this is not given, this is given. There is a full appeal on, because my lord, there is a time sensitivity to this. I'll tell my lord what's happening. These are imports coming into India. If the order is correct, then on a day-to-day basis, Indian industry is being imported by these guys dumping their goods into India. And in this period, there is not a single import in Haldia. The previous imports were in Haldia. They have come, my lord, to the court 23rd September. Today, my lord, we are in the middle of November because the ministry is considering the matter. And my lord, these are all, we all know as lawyers why we do these things. So, my lord, I am submitting. They have a full appeal on facts and law. Surely a tribunal can look at it and say, yes, technically there may be a breach of natural justice, but I've looked at the paper, there's nothing great in this information. Or the tribunal can say, all right, I've seen the information, you give your answer. Or the tribunal may say, sorry, I'm setting aside this finding, you go back. The trouble in a writ court is your lordship can say yes or no. Yes, this was looked at or not looked at. Then go back, fresh hearing, by which time this period elapses, then you start a fresh inquiry for the next period. That's the real problem. There is a time constraint in these matters. That's why there is a full appeal, which they have provided. In law, your lordship may direct the tribunal to hear.
My lord, may I deal with all the, I believe, my lord, that preliminary point is being decided now. Yes. No, then.
Take a point, my lord, because I'm appearing also for number 3, my lord. One or two things, my lord. As it comes to paragraph 74. Mr. Mukherjee says that he has come before this court on the ground of violation of natural justice. My lord, I think he has precluded himself by making this statement. My lord, can you see 74? 74. Volume 1 minute.
Writ petition.
Of the writ. He says your petitioner submit that there is no equally efficacious alternative remedy.
Yes,
Rashul
74.
got that? Your
Yes.
petitioner submit that there is no equally efficacious alternative remedy available to them as much as the Central Excise and Service Tax Appellate Tribunal is not taking up matters pertaining to challenges to determination by the designated authority, Directorate General of Trade. Now, once he says that, he admits to the fact that whatever he's saying in the writ petition is available to be taken up with the SESTAT, but SESTAT is not taking up matters. That is it. He can't turn back and now say that no, I've come before this court because of natural justice violation. Then he wouldn't have taken that one. And then your lordship will kindly see, we've got some cost list of the SESTAT. They are regularly, they are listing anti-dumping matters.
Yes.
No, my
No,
lord.
no,
That's not correct.
Yes, now my lord, may I? তুমি শেষ করলে আমাকে বলো।
And Mr. Mukherjee, subject to correction, he has referred to this court passing a judgment on this point. But he has not referred to it. But I know what he's going to refer to. That judgment was made CAV in the month of May, when this may not have been taken. So there was some time where the SESTAT was not working or was not taking up matters. Now, we have as late as cost title, cost.
No, but why was it not functional? It was not banned. Why was it then not functional? It was unmanned or
found by the single. Not found. Though the judgment was of September, I have information that was made in May.
20 seconds.
And
Could we have a look at the list? No, give us a copy also of the list.
A copy of the list, my lord. Copy of the list.
150 dollars. And
158 on.
Mrs. Sadhu was also referring to the Delhi High Court. The Delhi High Court was specifically directed that findings of the designated authority has to be challenged with the SESTAT as late as 22nd September 2025. May I just hand over the copy of
no,
that?
but if he takes a point that he has not been given full opportunity to make representation against, then in that case, a hearing before the appellate authority would not be as effective as it would have been, because that is always the law, that an appeal before the appellate authority will be an effective appeal only if the original authority against whose order the appeal is carried has given the appropriate hearing required.
But I'm asking myself this question, does para 74 say that? Para 74 is completely the other way around. That it could take up, but since it is not taking up, therefore I cannot have an alternate remedy. It's not that it's for violation of natural justice, SESTAT cannot take it up. And the way they have come up for election, they have also not taken responsibility of such pleadings. 74 has been afforded as a submission. And coming to this court and saying that the matter is not being taken up.
Submission of another key over.
Kindly appreciates. He has himself made the pleadings. I have not made the pleading. He has said that SESTAT has the power. It is an alternate remedy. Why is it not an alternate remedy? Because it's not taking up matters. That's it. If he even takes the part of natural justice, then he has admitted that SESTAT can take it up. Once he makes this pleading, So, kindly appreciate this point, But on a point, I am appearing also for respondent number 3. 3 on the.
You are appearing for respondent number
3. And Mr. Calvey for respondent number 4.
I hope you took his leave.
And 3. Please submit on behalf of respondent number 3.
Now, my lord, my lord, just take 2 minutes of your lordship's time. Now, my lord, section 9C, I'm not wishing it away. It is there. Now, my lord, my learned friend, my lord, has read para 74 with much vehemence. Kindly read para 75. 9C, I'm not wishing away. It gives, my lord, a right of appeal on, my lord, law and fact, as Mr. Salve argued, my lord. I accept that. Now, kindly have a look at 75. My lord, same page, page 42.
Yes.
Your petitioner further submits that inasmuch as the initiation of the anti-dumping investigation by respondent number 2 was bad in law, as well as the impugned notification issued by respondent number 2 was wholly without jurisdiction, as well as failure of the respondent to provide necessary information sought by petitioner number 1 amounted to violation of principles of natural justice, judicial discretion should be exercised in favor of the petitioner by entertaining. So I think in all fairness, my lord, 74 and 5, my lord, should have both been read with equal vehemence. I am not. Now, my lord, kindly come to para 76. And these have to be submissions. My lord, these are submissions. Now, my lord, your petitioners further submits that since the respondent number 2 has failed and neglected to consider the amount of subject goods manufactured for so and so for captive consumption, and whether after giving effect to the same, the application under Rule 5 of the Anti-Dumping Rules 1995 was maintainable or not, a pure question of law arises as to whether application under Rule 5 of so and so assessment and collection duty filed by respondent number 3 at instance of was maintainable or not. Hence, this honorable court should entertain the instant writ petition, taking into consideration the significant question of law and order. These are 3, my lord, paragraphs which ought to have been read together. My lord, rather than make a submission, my lord, that para 74, once you opened it and said this in para 74, you cannot come up and say that discussion cannot be exercised. Now, my lord, this is number 1. Now, my lord, I'll give your lordships the law here now. Now, my lord, kindly take, my lord, first, my lord, apropos, my lord, and may I just show your lordships, my lord, what happened? My lord, in this case, kindly take, my lord, there was a disclosure statement on, my lord, 10th of September 2025, my lord, which is, my lord, annexure P19, page 888, volume 6, my lord. Kindly have a look at it, my lord. 888, volume 6. Now, my lord, this is forwarded, my lord, to all the parties. We were one of the interested parties. And, my lord, our comments, my lord, were sought for, which your lordships will find, my lord, at, my lord, this disclosure statement, my lord, goes on till 946. No, 1 minute. And, my lord, we are to, my lord, as per the rules, my lord, comment on this. Now, my lord, we give our comments, my lord, on 17 September, which starts at page 947. Now, my lord, 954. 947 is of the association. My lord, our comment, my lord, that's, my lord, I believe, my lord, Mr. Obrotos Mujumdar is appearing for. My lord, 954. My lord, which is, my lord, the next volume, volume 7. Kindly, my lord, take, my lord, 954.
Yes.
Kindly come straight away. Kindly come, my lord, to, my lord, preliminary objection on public interest. That's how they deal with it in final finding. That's how what our comment is. My lord, on, my lord, the disclosure statement. Non-disclosure of ADD impact calculations. In this section of the disclosure statement, the authority has held that the impact of the proposed anti-dumping duty on downstream products would be minimal. We are the downstream, my lord, products. My lord, the material, my lord, is, my lord, material called, my lord, monoethylene glycol, my lord, which is used, my lord, in the manufacture of, my lord, synthetics and, my lord, petroleum products. Now, my lord, so, my lord, we are a downstream. The authority relying, now, my lord, kindly see, on its own recalculations. So, my lord, when they are recommending imposition of anti-dumping duty, they say that those who manufacture the same product in India won't suffer, or the impact will be minimal on them. Because it has to be fair, my lord, there has to be a balanced struck, my lord, on both sides. Now, kindly see this. Has found that the impact on, my lord, this is PSF, that's my lord, our my lord, product, my lord, would, my lord, polysynthetic fiber would be only 3.6%, and the impact on end consumer products such as PET. So, my lord, our raw material is PSF, two, my lord, manufacture PET bottles, and garments would be less than 1%. So, this is their price calculation for our product, what we use as raw material and the impact it would have, my lord, on, my lord, our product. Authority has further noted that none of the users have demonstrated inability to pass on this cost, and has therefore concluded that the duties if imposed would not significantly burden downstream industries. Now, my lord, kindly see our response. While the authority has stated that MEG represents only 16% of polyester stable fiber value and has presented a table showing a 3.6% impact, the precise assumptions and calculations underlying these conclusions remain undisclosed. In particular, the methodology adopted for allocating MEG costs, the values used for PSF pricing, and the conversion norms applied are not revealed. This prevents parties from meaningfully commenting on or verifying the correctness of the figures. Under Rule 16 of the anti-dumping rules, the authority is required to disclose all essential facts forming the basis of its decision. Without withholding the detailed workings fall short of this legal obligation. Then further, it is likely the authority has considered data submitted by the users in conducting this recalculation, whereby the same should have at the very least been disclosed to the users whose data has been relied on separately, if not as part of the disclosure statement. The Supreme Court in Reliance Industries versus designated authority so-and-so has similarly clarified that the designated authority cannot withhold workings or claim confidentiality in respect of data supplied by an interested party. Now, my lord, kindly see para 39, 2, my lord, 43, which is set out in our notes of submission. The Supreme Court in Reliance Industries versus designated authority has simply clarified that the designated authority cannot withhold workings or claim confidentiality in respect of data supplied by an interested party itself. That is our, my lord, pricing. Now, my lord, kindly see, we do not agree with the tribunal that the notification of the central government under Section 9A is a legislative act. In our opinion, it is clearly quasi-judicial. The proceedings before the DA is to determine the list between the domestic industry on the one hand and the importer of foreign goods from the foreign supplier on the other. The determination of the recommendation of the DA and the government notification on its basis is subject to an appeal before CSTAT. This also makes it clear that the proceedings before DA are quasi-judicial. Then, in the present case, the NIP computed by the DA was much lower than that computed by the appellant, and the reasons for such variance and detailed calculations were not disclosed by the DA to the appellant. No good reasons were given for reducing the cost price of electricity supplied by the appellant produced in its captive power plant. This was clearly illegal. The DA claimed confidentiality from the appellant about its finding on the data supplied by the appellant itself. In our opinion, there was nothing confidential in the matter, and hence reasons for not accepting the appellant's version should have been stated in the order of the DA. Then, in our opinion, Rule 7 does not contemplate any right in the DA to claim confidentiality. Rule 7 specifically provides that the right of confidentiality is restricted to the party who has supplied the information, and that party has also to satisfy the DA that the matter is really confidential. Nowhere in the rule has it been provided that the DA has the right to claim confidentiality, particularly regarding information which pertains to the party which has supplied them. In the present case, the DA failed to provide the detailed costing information to the appellant on the basis of which it computed the NIP, even though the appellant was the sole producer of the product under consideration in the country. In our opinion, this was clearly illegal. Now, my lord, the association is here. I am here, my lord. All the entire domestic in the consumers, my lord, of this product, my lord, in India are here. Their costing, my lord, has been calculated without giving them the basis, my lord, of my lord, how, my lord, this was done. My lord, DA, my lord, cannot claim confidentiality. Final finding.
There is no confidentiality claim here.
No, no.
The finding is data is given.
Yes, now, my lord, kindly have a look at the finding now. I'm grateful, my lord. The final finding, my lord, kindly come to, my lord, 23rd September 2025. My lord, this is, my lord, volume, my lord, the last volume, annexure P20. Page. My lord, page, my lord, 9. My lord, it starts at page 971. My lord, the final finding, annexure P21. Now, my lord, kindly come to, my lord, our submissions, my lord, are also, my lord, recorded. My lord, 978 and 979. Now, my lord, kindly come to, my lord, examination by the authority. Now, my lord, kindly have a look at submissions of interested parties. Oh, I want to show this portion. Then submissions of domestic industry. Now, my lord, kindly come to 980 examination, etc. The normal value, export price, etc. My lord, I'm trying to look for, my lord, the working. My lord, kindly have a look at, my lord, page 996.
986. 996.
986 first, my lord.
86.
996, yes. And my lord, kindly now come to, everything's blank, your lordship seen. Now kindly come to 1020.
1020.
Yes, now just above that, para 123. Based on the landed price and NIP determined as above, injury margin as provisionally determined is provided in the table. Where is the calculation with the greatest of respect of my price? And my lord, para 142 now, at my lord 1026. Para 142. Kindly now, my lord, read this. With regard to polyester staple fire, authority has examined the calculation submitted by Bhilosa and found them to be inaccurate. For example, when computing impact of anti-dumping duty on so-and-so, user has expressed proposed so-and-so as percentage of value, clearly ignoring the fact that increase in prices of so-and-so would only impact the cost attributable, which constitutes only 16%. Same has been illustrated. Then, my lord, where are they getting this working from? Huh? Yeah. My lord, it's all asterisks. My lord, the impact was 3.6%, which I read out. My lord, bottom of the table, my lord, computation method. Percentage of impact. Impact on PSF, 3.6. PSF is a raw material. We said, how do you get this working sheet? Where is my working sheet, my lord, which has been considered? And my lord, what is the working? My lord, there is a method, my lord, computation method A, B, C, D, E is equal to D over B, MEG cost is so and so. And all the figures are blank. Completely absent. Now, my lord, kindly have a look at two of the rules, my lord, which I want to show your lordship. Essential facts. Now, my lord, first, my lord, kindly take, not rule 7, rule 16, come straight to the point. My lord, rule 16, I don't, acha rules nahi. Huh? No, answer করছি. First, natural justice, rules দেখাবো তো. You don't even give the essential facts and say, I'll argue whether breach of principles of natural justice are relevant or not. Now, my lord, kindly come to, my lord, disclosure of information. Just take out 1989 Supreme Court. Kindly see, my lord, rule 16. The designated authority shall, before giving its final findings, inform all interested parties of the essential facts under consideration which form the basis for its decision. So, my lord, final findings is not what is relevant here. Before, and that is the disclosure statement. When they ask for my comments, give this. They have not given. Even in the final findings, they have not given. And I'll go and have a half-baked appeal. That is exactly what's deprecated. Now, my lord, I'll cite two decisions before your lordship. On, my lord, essential facts. My lord, these are necessary, my lord, to be, my lord, furnished. It's, my lord, a procedural safeguard of utmost importance because the jurisdiction being exercised is quasi-judicial and it's a list between the domestic industry and the others. Now, my lord, kindly take. First, my lord, is, my lord, Supreme Court, why are you all on? My lord, I've cited Reliance, which is one Supreme Court, that this is required to be given. Now, my lord, I rely on, my lord. Yes. I have it here. Yeah. I'll take it. Not in this. Oh. Here. My lord, this is 1998, 8 Supreme Court cases, page 1. My lord, kindly come straight away to paragraph 14, my lord. My lord, your lordship has that, my lord. Para 14 first. The power to issue prerogative writs under Article 226 of the Constitution is plenary in nature and is not limited by any other provision of the Constitution. This power can be exercised by the High Court not only for issuing writs in the nature of habeas corpus, mandamus, prohibition, quo warranto, and certiorari for the enforcement of any of the fundamental, but also for any other purpose. Then, under Article 226 of the Constitution, the High Court, having regard to the facts of the case, has a discretion to entertain or not to entertain a writ petition. But the High Court has imposed upon itself certain restrictions, one of which is that if an effective and efficacious remedy is available, the High Court would normally not exercise its jurisdiction. Then, my lord. So, my lord, my para 74 was, there's not even that here because it's not functioning. Para 75 and 76 is, even if there was, my lord, court should not exercise its discretion. Now, my lord, kind. But the alternative remedy has been consistently held by this court not to operate as a bar in at least 3 contingencies. Namely, where the writ petition has been filed for the enforcement of any of the fundamental rights, or where there has been a violation of the principles of natural justice, or where the order or proceedings are wholly without jurisdiction, or the vires of an act is challenged. I have not yet come to the jurisdiction issue. I'm just on natural justice. There is a plethora of case law on this point, but to cut down this circle of forensic, we would rely on some old decisions on the evolutionary era, etc. So, my lord, this is now, my lord, it's been reiterated. Sarah Godrej later, concurrent judgment. Which one? No, no, the concurrent judgment. Now, my lord, 2023 SCC online SC 95. Now, my lord, kindly come to para 6. My lord, Whirlpool is cited. My lord, the 4, my lord, examples, my lord, are given. Now, my lord, kindly come to para 12. Oh, sorry, para 8. My lord, kindly take para 8, most important. That apart, we may also usefully refer to the decisions of this court reported in so-and-so. What appears on a plain reading of the former decision is that whether a certain item falls within an entry in a sales tax statute raises a pure question of law, and if investigation into facts is unnecessary, the High Court could entertain a writ petition in its discretion, even though the alternate remedy was not availed of. And unless exercise of discretion is shown to be unreasonable or perverse, this court would not interfere. In the latter decision, this court found that the issue raised by the appellant to be pristinely legal, requiring determination by the High Court without putting the appellant through the mill of statutory appeals in the hierarchy. What follows from the said decision is that where the controversy is a purely legal one and it does not involve disputed question of fact, but only questions of law, then it should be decided by the High Court instead of dismissed. My lord, mandate, it should be decided. Now, my lord, what is the question of law here? My lord, kindly have a look at the initial notification. My lord, once, my lord, in this matter. My lord, which is, my lord? Initiation, my lord. My lord, now, my panic shut. My lord, P7, my lord. Page 433, volume 3. My lord, page 433. Now, my lord, this is very important. Having regard to Customs Tariff Act, etc., as amended, Chemicals and Petroleum Association of India, hereinafter referred to as the Applicant Association, has filed. I'm sorry, my lord. Your lordship has. Yes.
Catch up with you.
No, I'm sorry, my lord. My lord, 27 September 2024. My lord, kindly see. My lord, 5th line. Chemicals and Petroleum Association of India. My lord, who Mr. Roy, my lord, purports to represent.
Why purports?
I was waiting for that reaction from him. Now, my lord, has filed an application before the designated authority on behalf of Kindly see Reliance Industries Limited seeking initiation of so and so. So, my lord, real, my lord, applicant, my lord, is Reliance. But anyway, my lord, he is representing, my lord, the domestic industry. Now, my lord, kindly come to, my lord, page 435. The subject countries are given and the period of investigation, my lord, is given. Yes. Now, my lord, kindly have a look at rule 2B, my lord, of these rules. I have to show that. Now, my lord, kindly see, my lord, 2B.
Yes.
Domestic industry, kindly note this, means the domestic producers as a whole engaged in the manufacture of the light article and any activity connected therewith, or those whose collective output of the said article constitutes a major proportion of the total domestic production of that article, except, kindly see, when such producers are related to the exporters or importers of the alleged dumped article or are themselves importers thereof. In such case, the term domestic industry may be construed as who referring to the rest of the producers whose data, my lord, was not even, my lord, before, my lord, the tribunal. And this, my lord, was inserted, my lord, with effect from, my lord, 1st of December 2011. Sorry, my lord, my lord, this was inserted, yes, my lord, from, my lord, 2011, 1st of December 2011. So, my lord, here, now kindly read, my lord, paragraph 8 and 9
Of?
that, my lord, initial notification.
Yes.
Now, my lord, the present application has been filed by CPMA on behalf of Reliance Industries Limited. The application has also been supported by Indian Glycol. Apart from the two producers, there is another producer, Indian Oil. Reliance Industries, not the others, constitutes a major proportion in terms of Rule 2B of the AD rules. Reliance Industries Limited has imported the subject goods from the subject countries during the period of investigation. It is noted that the volume of imports made by Reliance is less than 1% of total demand and around 1% of its production. What are facts say? Now, my lord, I'm not going into facts. We say even these figures are not correct. The question is, it's an admitted. Sorry, what do you say? My lord, I'm not going to the facts. I'm saying admitted position is, my lord, that it is also an importer. So, my lord, could, my lord, the, my lord, designated authority have, my lord, initiated, my lord, my lord, investigation to determine anti-dumping duty at all? And final finding, my lord, is at 1034. We raised this objection, my lord. Tell me. Now, my lord, first, my lord, kindly take the final findings. My lord, 971. My lord, at, my lord, page 980 at paragraph 17. Now, my lord, para 17.
Yes.
To hold, my lord, para 17, it says the authority notes that Reliance has imported the subject goods from the subject countries. However, such imports constitute only 1% of their total production and the overall demand. This limited import does not alter the applicant's nature of business from so and so. Accordingly, the applicant is eligible to be considered. My lord, with the greatest of respect, where is that, if I may ask myself the question, that the applicant who imports can be considered to be part of the domestic industry? In fact, my lord, to be, my lord, the entirety of the domestic industry. No one else. Now, my lord, page, my lord, 1034. Volume 7, my lord, 1034. One minute. Kindly have a look. ऐसे बातों की types है. My lord, 153. Now, my lord, and with respect to imports made by RIL during the authority notes that imported the subject code only during the period of inquiry, and such imports account for less than 1%, which is minuscule. RIL did not even during the previous years of the injury period. My lord, how one, etc. I'm not even going into those factuals. I'm saying importer. And the period of investigation, he has admittedly imported. My lord, could, my lord, inquiry have been initiated, my lord, by, my lord, Reliance, or at the instance of Reliance? I am, my lord, raising, my lord, a jurisdictional issue here. I'm not going into, my lord, whether these findings of facts are correct or not. I'm saying, assuming, my lord, everything is correct on the face of it, and this, my lord, requires, my lord, an interpretation by this High Court, my lord, as to what, my lord, rule, my lord, 2B is. Now, my lord, with regard to whether there is, my lord, a forum of appeal which is functional, I want to, my lord, now show your lordship. My lord, what is, my lord, this forum of appeal? Kindly take, my lord, the Act once. The Customs Tariff Act. My lord, kindly take, my lord, 9C.
Yes.
An appeal against the determination or review thereof shall lie to the Customs, Excise and Service Tax Appellate Tribunal, and what we refer to as CSTAT, constituted under Section 129 of the Customs Act in respect of the existence, degree and effect of, my lord, kindly see, 1 includes dumping. And, my lord, 2, import of any article into India in such increased quantities and under such conditions so as to cause or threaten to cause serious injury to domestic, etc. Now, my lord, kindly have a look at, my lord, subsection 5.
Yes.
Every appeal under subsection 1 shall be heard by a special bench constituted, first, my lord, it's a special bench, constituted by the president of the appellate tribunal for hearing such appeals, and such appeal shall consist of who? The president and not less than 2 members, and shall include one judicial member and one technical member. Now, my lord, kindly see a High Court decision on this, where, my lord, the central government was represented. Raja's judgment, you have a copy. My lord, paragraph 50.
Part of the compilation. We have handed over the compilation.
Which compilation? Oh, jara dile. My lord, I believe it's in their compilation also.
Serial number 6.
My lord, serial number 6.
Yes.
Kindly see, my lord. Paragraph 50 of that. I don't know what page of the compilation that is. Serial 6 is fine, but is your compilation number?
Yes.
So just give the page number. Paragraph 50. Lordships, kindly read it from their compilation, my lord. I don't want to multiply, my lord. I'm told it's there.
Para 50 is page 134.
My lord.
Para 50. 134.
Paragraph 50, my lord, which is page
134.
134. The compilation. Dadila made. Kindly see, my lord. Para 50.
Yes.
From the above, it is crystal clear that the High Court, while exercising jurisdiction under Article 226, my lord, this learned judge pointed out to me, my lord, he had dictated plenary, he requested this to be corrected, and the staff said, no, planetary is what is gone. So I, my lord, pointed out to him, obviously, my lord, there's somebody interested in astronomy or astrology, my lord, the amongst the staff, my lord. Plenary powers and presence of an alternative remedy does not interfere with the exercise of his jurisdiction in a fit case. The exercise of jurisdiction is discretionary, and the High Court follows self-restraint to weed out matters where adequate alternative remedy is provided for. In this context, it is thus necessary to consider whether the petitioner at the time of filing of the petition had availability of alternate remedy. I find that though an appellate provision has been provided for, the petitioner has stated on oath that the appellate authority so-and-so had not been constituted for more than 1 year and is not functional. In support of the aforesaid decision, the roster of CSTAT from so-and-so has been disclosed. In my view, in the light of the above, matter has been taken up for, in my view, simply because there is an appellate forum available, though such forum is non-functional, it would be wholly unjust and unfair to direct the petitioner to approach such forum. In the instant case, since the tribunal had not been functional, this court had entertained and accordingly taken up the matter for hearing on merits. That on everything it had taken up. Ultimately, it set, my lord, notification was published during the hearing. It was set aside subsequently, and my lord, the government has acted on it, accepted it. Government has not come and said anything. And my lord, some causeless, my lord, has been given to your lordship. Now, my lord, only that one matter, because of the Delhi High Court order, kindly see 158, 159, 160 and 161 of their compilation.
Yes.
My lord, may I start from, my lord, page, my lord?
158.
No, 164, from, my lord, the last page. Because that goes chronologically. My lord, Mr. Vasu Shastri, my lord, mixes the dates up always. So, my lord, I'll start with, my lord, 23rd September 2025. It is pointed out by the learned counsel for the appellant, and my lord, this is SC law, your lordship notes, and the learned authorized that the Delhi High Court has yesterday passed. Parties, however, have not placed, though they have stated the matter has been directed to be list this appeal in January. So this special bench is next sitting, my lord, in January. Then you say a lot of things. Now, my lord, kindly come to 29th May 2025, 163. May. My lord, kindly see the period where this bench has been constituted. In the event of non-sitting of the bench, the adjourned dates of listed matters will be available on so-and-so in the daily orders court proceedings. Now, my lord, we don't know what happened on 29th May. Then, my lord, 23rd April 2025, 162. Same. That was High Hope Furniture. This is AGC, Vinthiani. And my lord, 16 September, my lord, is my lord where SC law, my lord, starts. So, my lord, we have a situation where this, my lord, bench, my lord, according to them, my lord, it was listed. We don't even know, my lord, whether things really happened on that date. My lord, first is, my lord, on, my lord, 14th, my lord, of May. That's page 159. Then, my lord, the next date, my lord, is, my lord, 14th of May is 159 and my lord 162. Then, my lord, is, my lord, 14th of July. Then, my lord, is September. And then, my lord, now that list, my lord, will come in January 2000. This is what's happening. Before that, for 1 year, my lord, they didn't even sit. It's not a regular, my lord, bench. It's constituted each time, my lord, by the president. Because all tribunals, my lord, are short staffed. There are other issues, my lord, which are, my lord, arise, my lord, in CSTAT, your lordships aware, my lord, customs, my lord, everything, my lord, arises. But, my lord, this is now, my lord, kindly take just one last case which I wish to cite. My lord, this is, my lord, 1990. 4 Supreme Court cases, 594. My lord, this year was the 19. Oh, sorry. I remember this case because it's my name, my lord, with a different spelling.
You hide your identity.
But this decision, my lord, was, my lord, in 1990. And since Mr. Salve is here, I, my lord, remember, my lord, my first visit to the Supreme Court. I had, my lord, had 2 years in the profession. My lord, Mr. Salve was arguing before a bench presided over by Justice Shobhushaji Mukherjee. And, my lord, the other side, my lord, was Dr. L.M. Singhvi, and it was Mahabir Auto. My lord, where, my lord, we were, the new law, my lord, was being expounded by, my lord, Mr. Salve. My lord, opposing the new law, my lord, Indian Oil, my lord, exercising monopoly powers, and Mr. Salve was, it's purely contractual dispute, my lord, and should not be my lord,
It
entertained.
should not be entertained.
He's argued to the contrary number of times, but he finds himself, my lord, arguing this point quite often. So, my lord, here, my lord, kindly come to, my lord. It's a question of an administrative authority as well. Para 9 once. My lord, at page 602. And my lord, when after, my lord, all this, my lord, kindly come straight away to, my lord, paragraph 32. My lord, this is one, my lord, where, my lord, reasons, my lord, were treated as part of, my lord, the element of natural justice, my lord. Kindly see para 32. My lord, Siemens Engineering is referred to, my lord, on a revision application, and my lord, the quoted period. Yes. Yes. Now, my lord, kindly see. It is now settled law that where an authority makes it must record its reason. Every quasi supported. If courts are law to be representative, etc., then it. Now, my lord, kindly come to paragraph 36. 6-1. No. There. I'm sorry, my lord. Before that, I must show your lordship the quotation. Another part of the quotation of my lord Siemens, from Siemens, my lord 611 Placitum B. The rule requiring reasons to be given in support of an order is like the principle of ordae alteram partem, a basic principle of natural justice which must inform every quasi-judicial process, and this rule must be observed in its spirit, and mere pretense of compliance with it would not satisfy the requirement of law. Then, my lord, 36. Because the appeal also has to be an efficacious remedy, my lord. Kindly see, my lord. Reasons when recorded by an administrative authority in an order passed by it while exercising would no doubt facilitate the exercise of its jurisdiction by the appellate or supervisory authority. But the other considerations referred to above, which have also weighed with this court in holding that an administrative authority must record reasons for are of no less. These considerations show that one raised by serves a salutary purpose, namely it excludes chances of arbitrariness, ensures a degree of fairness in the process of decision. Then, my lord, in our opinion, therefore, this is on requirement, then 39. Kindly see. My lord, 614. The object underlying the rules of natural justice is to prevent miscarriage of justice and secure fair play in action, as pointed out, etc. This is, my lord, the salutary purpose. My lord, to say you have an alternate remedy, my lord, with the greatest of respect, my lord, is not good enough. The question is, even assuming there is an alternate remedy, which way will the discretion be exercised? And, my lord, the last Supreme Court says, recognizes 4 exceptions to, my lord, going, and says there's a 5th if there's only a question of law involved. My lord, I've taken the point of jurisdiction, taken the question of law, and, my lord, natural justice. Factual I've not gone into at all. Because on this ground itself, my lord, the writ can be entertained. And in fact, ought to be entertained with the greatest of respect, my lord.
Mr. Mukherjee, so far as merits are concerned, these will be your submissions on merits.
I have more. On my lord, the data which has been provided, my lord, I have a lot more, my lord.
Because I will in any case not be deciding the factual matrix of it.
Has to be. Exactly.
If I am
Then it goes back, my lord.
Yes, that is the best
Yes.
that can happen if
Correct.
I am satisfied
Correct.
with the jurisdictional aspect, or
Correct.
I
Absolutely.
take it that this is the point which you are
Correct,
arguing,
correct, correct.
unnecessarily calling for
Correct.
affidavits or entering into
Correct.
that domain will
Correct.
serve nobody's purpose.
Correct. Correct.
Either you are in or you are out.
Correct.
If I am satisfied, because there are 2 questions, Mr. Salve, which have been posed by Mr.
Yes,
Mukherjee.
my lord. I'll answer that straight away.
One is that it's wholly without jurisdiction in view of the definition of domestic industry in rule.
Correct, my lord.
And
Covered against him by a division bench of this court.
of natural justice.
Yes, my lord, the second point is covered against my learned friend by a division bench, which says, when it says unless you are an importer, a sporadic import will not disqualify you. It's a quantum check. Reliance is one of the world's large manufacturers of MEG. When the factory is closed, if you make one consignment import, that doesn't mean you are an importer in the industry. My lord, the division bench of the Calcutta High Court has dealt with this. I'll show it straight away.
Yes, Mala, one more thing I want to add. Just one more thing. It will just
Sure,
take
sure.
2 minutes. Yes. Yes, the other question of law is,
Yes. Yes, that is why, because it will be better so that I can decide the entirety.
Yes, yes, yes.
Into facts into at all.
Yes, Mr. Salve, as I am appealing for respondent number 5. And I am supporting Mr. Mukherjee because I also participated in the proceeding.
show me that 65%.
My lord, I believe we have not been impleaded in the other case. And I don't have a copy of his papers.
That's a different rate.
This is yet to be
Mr.
taken
Salve,
up.
that's a different rate.
May I just indicate your lordship?
No, I just asked just one more point, my lord. My lord, kindly take, my lord, the rules one.
I just wanted to mention there are 2 other petitions. I hope those are not being taken
No,
because
no,
they
no,
are
no,
not
no,
parties.
no,
Yes.
no.
No, they have not yet been called.
Lordship.
Rule 5.3. Yes. Now, my lord, kindly take rule. My lord, rule 5.3b. 3A. Proviso, my lord. Proviso.
5.3a.
Yes, ma'am. Kindly see. Yes. My lord, kindly see, my lord. The designated authority, now, my lord, the negative precatory words, shall not initiate an investigation pursuant to an application made under sub-rule 1 unless A, it determines on the basis of an examination of the degree of support for or opposition to the application expressed by domestic producers of the like product that the application has been made by or on behalf of the domestic industry, provided, now kindly note this, that no investigation shall be initiated if domestic producers expressly supporting the application account for less than 25% of the total production of the like article by the domestic industry. This, my lord, a jurisdictional fact. Now, my lord, 2 facts, my lord, which I wish to show your lordship. 670. Annex of 1. P14, my lord, volume. This volume he doesn't give. Now, my lord, kindly see para 10.
Where are you reading, Mr.
670. This is
Thank you.
rejoinder submissions.
670.
Yes, para 10, my lord. Last 4 lines.
Yes.
Last 4 lines of that. 65% of RIL's total MEG production is self-consumed for captive use. That's, my lord, very important. It's not its total production is in the market. Only 65.
35 it must be important.
Correct. And that 35.
No.
You'll make your submission. Now, my lord, that 35, my lord, has to be, my lord, looked into. They've looked into the entire production. Second, my lord, the supporters, my lord, of, my lord, this, the two others, my lord, who are in the picture. One is Indian Oil, which is state neutral. It does not support it. The other is, what is the name? In Indian Glycol, whatever, my lord, there's another IGL. Now, my lord, it doesn't have, my lord, 25%. Finding the my lord, kindly take page 960 so that there's no problem, my lord, with regard to this later. Disclosure statement. My lord, this is the disclosure statement. Our comments to it, which I just shown, my lord, P, my lord. Are coming to the second.
Page 960.
This is the second one, my lord. Second P20. This is it, right? My lord, kindly take page 960.
Yes.
Para 25. My lord, para 23 and 25. My lord, kindly see para 25. It's particularly critical since RIL is the only integrated producer of the PUC, and moreover, approximately 65% of RIL's total MEG production is self-consumed captively. As a result, this is these underscore the risk of relying disproportionately on RIL's performance to draw conclusions. And this has not been determined, my lord, at all to what is in the market. And on, my lord, others, I have stated para 22. Sorry, 23, my lord, not 22. Same, my lord, 960. Fourth line onwards, without disclosure or verification, its role as supporter cannot be treated as meaningful for the purposes. Support in form alone, whether does not contribute to it. Because it has to be shown, my lord, that 25% supported. Where?
What is the para 24, Mr. Mukherjee? It says users further submit that the authority has misconstrued their arguments. The issue is not that RIL's limited imports 1% of production and demand disqualified from being treated as a producer. Rather,
it's one of injury analysis. Correct.
So then, are you?
No, I'm not giving up the legal point, my lord. Legal point still remains. But this is over and above, my lord, on, my lord, domestic injury. Because if otherwise they are not, I'll tell your lordship, my lord, there's a Guwahati High Court division bench, which says the expression may, my lord, gives discretion.
To the authority.
Yes, to be. And division.
There's a lot of factual data. If your lordship is going into it, we can show how he has gone into domestic injury. But I thought my lord said, don't get into the facts.
But my lord, over and above that, my lord, this is, my lord, also, my lord, a legal submission which I made, which is also there, my lord, in, my lord, this note that we've given. But, my lord, more significantly, my lord, is with regard to IGL, para 23, that it has 25%. And 28, it summarizes on this supporter aspect.
So this lies in the realm of dispute then, whether it's 1% import or more than 1% import.
No, that is, my lord, when I argue, my lord, that it's 1%, as my lord, a law point, my lord, I accept 1%. But what is in dispute?
Factually, is it not in the realm of dispute? Because you
Actually, it is, of course.
It is.
Because we have no data on this. In fact, that's summarized in para 28.
So for that aspect, how would the writ court deal?
My lord, if your lordship satisfied that the bench is not sitting, my lord, suppose your lordship holds on the preliminary points against me and says, no, I have to pursue an alternate remedy, then that has to be decided there.
Yes.
That's arbitrary.
Determination has happened one line. There's no place.
670.
Yes, Mr. Majumdar, you have to add something.
My lord, may I, my lord, have your lordship leave?
Just 5 minutes of your lordship. First, I adopt the submissions made by Mr. Mukherjee.
You are appearing for whom?
When I am appearing for respondent number 5, and I am supporting my lord the petition. I participated in the proceeding, but this is an association before your lordship.
Just a minute.
Only the cost title is to be corrected, my lord. The name of the association has been incorrectly given, my lord. I will indicate that, but that's not an issue.
Yes.
But the question of law which arises before lordship indisputably, without having regard to the fact that whether RIL, admittedly being an importer, during it was importing 1% admittedly, during the period of investigation, could have triggered the initiation of the proceedings under the anti-dumping rules. This is the pure question of law. Now, my lord, this also involves, my lord, ascertainment of a jurisdictional fact, having regard to the designation of domestic industries provided for in Rule 2B of the rules. Now, question may arise that when do you raise or where do you raise jurisdictional fact? Well, this jurisdictional fact was raised, that non-existence of this jurisdictional fact was raised before the authority itself, as would be evident from, my lord, 1034 and also 980 of the impugned decision. Now, my lord, it is well settled. Well, I will cite only one authority. This is 2007 1 SCC 732. Well, interesting, my lord, this proposition of law was canvassed by Mr. Salve in this judgment. This is that concession in the matter of perquisite. Rule 3 of the income tax rules were examined. Kindly take, my lord, paragraph 74 of the SCC version. This is also reported in ITR. I am taking a lordship to SCC. And kindly take paragraph 74. 2007 1 732, para 74, Arun Kumar versus Union of India. A jurisdiction, my lord has got that. A jurisdictional fact is a fact which must exist before a court, tribunal, or an authority, but this is the designated authority, assumes jurisdiction over a particular matter. A jurisdictional fact, so domestic industry or not domestic industry, is one on existence or non-existence of which depends on the jurisdiction of a court or a tribunal or an authority. It is the fact upon which an administrative agency's power to act depends. If the jurisdictional fact does not exist, the court, authority, or officer cannot act. If a court or authority, well, this is where we come in because it's a question of maintainability right now, wrongly assumes the existence of jurisdictional fact, such fact, the order can be questioned by writ of certiorari. So in my most respectful submission, the issue of domestic industry, whether Reliance could have maintained that application or not, or could have triggered the proceedings or not, is a jurisdictional fact. I believe, man, Mr. Salve, the division bench, Guwahati High Court is not a division bench judgment, it's a single bench judgment, first. Secondly, my lord, that is referred to in the initiation initiation order itself, notification itself. And so far as the division bench, subject to correction by Mr. Salve, the only division bench judgment which we could trace is by Madras High Court. That judgment has been set aside by the Supreme Court and the issue has been left open. Subject to correction. Well, I will stand corrected. Well, it may so happen a different judgment may be set. But these are my respectful submissions.
My lord, may I request your lordships to turn to the compilation of judgments given? The division bench we are relying on is Calcutta.
Yes, just a minute.
A copy of the compilation may be given. Yes,
Of course, of course.
yes, we give it to the petition.
Yes, sir.
Yes. If your lordship is pleased to, my lord, turn up page 65 this in this compilation. I have unfortunately a soft page, page 65, but it's the judgment of the
Yes, I've got it.
yes,
State
your
of
lordship.
Gujarat Fertilizers.
Correct, my lord. If your lordship straight away turns up, paragraph, unfortunately, there's no para or page number in this. I have a page 71.
Page 71.
Yes, my lord, it has a paragraph which starts, thus it is very clear
Yes.
that the definition of importer as mentioned has to be understood in the context of protecting indigenous industry producing the same material. Here we notice the fact, of course, going by the statement made by the complaint of the appellant to the appropriate authority, that 15% of its production is imported, and that too casually to meet the customer's demand during a time when production was disrupted. This quantity of import is very insignificant portion of the total import of the exporting. According to us, realistic and logical meaning should be the person who's carrying on the business of import exclusively for trading is the importer under the said rule. We have examined the object clause of the memorandum and nowhere do we find it carries on the business principally of import of melamine. It's carrying on the business amongst other manufacturing heavy chemicals of every description, whether required for civil, commercial, or military defense. We record the trial court did not decide the examination of the object of memorandum. We think the exercise is paramount. Without the same, appellant could not be held to be an importer in the said it is intended by the rule. While reading the rule, we are unable to accept the meaning that the word importer given by the trial judge. It seems to us trial judge has adopted the definition of importer in Customs Act and has applied the meaning in common sense parlance. This cannot be done as considering contextually as argued by Dr. Chakrabarti. The definition in the Act is of general application, which includes both regular trader and exclusive consumer. Anti-dumping rules have not been framed under the Customs Act. The rule has been framed under the CT Act. And then the whole discussion goes that that an importer here is a trader importer. And if your lordship sees the next paragraph, look at the last para, my lord. Before we part with this matter, we are of the view that in cases of this nature, the writ court should not have entertained, as the action is at the threshold and further maintainability is depending on facts made out in the complaint. Such a point could be agitated before the appropriate authorities, requires some material on fact, not the legal provision alone. It is not a case of inherent lack of jurisdiction for which extraordinary jurisdiction has been invoked. It's a question of jurisdiction relatable to a fact, and the fact is required to be examined by the fact-finding authority, and we find the exercise called writ court will not encourage such a person, etc. Now, my lord, I tell your lordship the problem of running these kind of points. If your lordship turns up the order, my learned friend read page 670, my lord, his rejoinder submission.
Yes.
And your lordship recalls, your lordship is made it clear to my friend, your lordship is talking of, your lordship is considering jurisdiction, not the impact. There is an admission at page 670 in para 10. Your lordship has that one?
Volume 5.
Volume 5, what my learned friend read, man.
Yes, yes.
While RIL may technically meet the standing requirement under the anti-dumping rules,
Yes.
there is authority must also consider a broader state of Indian industry, etc. That's not a quantum of appreciation. So their case was, and I'll tell my lord why. If your lordship sees the finding at page 1034 in the findings, because your lordship's read, my learned friend pointed out, 65% we consume, 35% we put in the market, which is a very sizable amount. Now, when our factory went down for maintenance, we imported a small quantity. And that's in para 153. Your lordship has para 1034.
Yes, 153 I have.
Yes. With respect to import by RIL during the injury period, authority notes that RIL has imported the subject goods only during the period of investigation, and such imports amount to less than 1% of its total production and sales, which is a minuscule quantity. RIL did not import the subject goods during the previous years of the injury period. How does this become a jurisdictional issue? Because you have a period of 3 years, the last 3 years you're trying to see. In one of these years, you import some small amount. That doesn't mean you're a regular importer of these goods. And as the division bench has explained, it's really not a person who's trading and importing and trading. So, this is not some magic mantra saying, oh, you imported one minuscule, therefore you're no longer a domestic industry. Now, that's the short answer to this.
Mr. Mukherjee joins issues on this, Mr. Salve. He says it is not 1% or less than 1%, it's more.
But then that has to be argued, no? Who will go into these facts? But if I say it's 5%, you say it's 1%, these are disclosed facts. He's not said this is not disclosed. These are disclosed facts. Now we will argue. That's why I said this is a fit. And my lord, all these, the tribunal is not sitting and wasting your lordship's time showing you cause list doesn't help. Your lordship will direct the tribunal to you. It's a subordinate court, my lord. I mean, I know it would be utopian if our courts, my lord, had a lot more time than our tribunals. Unfortunately, the reverse is the case. The pressure on your lordship's board is far more than the pressure on any tribunal. Now, my lord, this is the short answer to the jurisdictional point on importer. Your own submission says technically you meet the standing. But your lordship is only considering technically. Not whether it's a broader state of industry. That then comes into the area of appreciation of facts. So that's the short answer to this. On the second, my lord, I'm sorry, there has been such a muddle up. There are 4 pages your lordship needs to see, and it becomes clear as ever. There are 2 separate products. That's why I asked my lord whether the other petition is being taken. The confidentiality is not with respect to PET. PET, the authority has gone by Mr. Mukherjee's client's figures, which are disclosed. The figures which he showed asterisks relate to another product.
Mr.
I'll show
Salve,
that straight away.
to that one so that it clarifies.
Please turn to Malad page 1026, where the asterisks were shown.
Yes, 1026.
Yes, Malad. Para 142. Please see the second line, Malad.
Yes.
For example, when computing the impact of ADD, that is anti-dumping duty, on polyester staple fiber, PSF, not PET, the user has expressed the proposed ADD on MEG on the total value, ignoring the fact that the increase on the account on MEG would only impact cost attributable to MEG, which is only 16%, etc. And this is where the figures are not given. Now, why are these figures not given? Because this user is one company called Bolseri. And under the rules, Bolseri said, keep my figures confidential. I'll show that in a minute, which it can. What my learned friend is concerned with is para 144.
Para 140.
4. 2 paras down. On the other hand, domestic industry has submitted computation of ADD on different end products, namely PET. You not have that, man?
Yes.
And garments. The same is illustrated below. Full details are given.
So the petitioner is concerned with PET bottles and figures in respect of those have been provided.
Fully provided. He read the wrong table. Now the problem in this is, Marat, if your lordship turns up the rules, because my learned friend read that a little quickly. In Reliance, they had, in the Supreme Court judgment, they had come on a finding on the appellant's figures without disclosing how they computed. So the Supreme Court said, why are you holding back the appellant's figure from himself? Where is the confidentiality? Now look at the rule, Marat. Rule 7. It's in the compilation, page 24, Marat.
7.
Because the general rule which was read was rule 6, that you have to give all the details, etc. And
Yes.
there is no challenge to rule 7.
Rule 7 is at page 24.
Yes, Marat. Notwithstanding anything contained in 2, 3, and 7 of Rule 6, Sub-Rule 2 of 12, Sub-Rule 4 of 15, and so on. So, copies of applications or other information provided to a designated authority on a confidential basis by any party shall, upon the designated authority being satisfied as to its confidentiality, be treated by it as such, and no information shall be disclosed to any other party without specific authorization of the party providing such information. The designated authority may require parties providing information on confidential basis to furnish non-confidential summary, and if, in the opinion of the party providing such information is not susceptible of summary, such party may submit to the designated authority a statement of reasons why summation is not possible. Now, this all, Malad, relates to Bolseri. Bolseri asked for confidentiality, but there nobody said give us these figures, because there are 3 products which will be affected if this duty is imposed. One is polyester staple fiber. Now, my learned friend's clients doesn't manufacture polyester staple fiber. PET. PET figures are all there. You can't say because that is kept confident. This is the problem, Malad, in coming to a red court saying, look, one document not given. I don't want to go to the tribunal. Tribunal will ask them, how you prejudice by this? Why do you need to see this? Because, Malad, it's very difficult to completely, in one sense, move away from the facts and pick up one document and say, this is not given to me. Well, these are the nature of the finding here is you have to come to a broad assessment. A domestic industry goes to you and saying, look, these are coming from foreign countries, they're dumping goods. Now, that's a very serious matter. And in GATT, we have signed our treaty, which allows us to impose. But as a protection, we said, yes, we'll do it openly, transparently. So you have a designated authority. Everybody is heard. Now, Malad, these are competitors also. So I may give figures, somebody else may give figures. I may want my figures to be kept confidential because you go into details of what the cost of production is, etc. A lot of importers hold their figures back, which are only given to the authority. This rule recognizes nobody has struck down Rule 7. Now, Malad, that authority makes an assessment of what is the injury, what is the margin of injury. Will it increase the price to the domestic product? Will the Indian consumer be hurt? As against which, what is the injury cost? These are all elements and factors which they put together. Now, Malad, your lordship as a reed court is hardly in a position to say whether 8% injury is good enough or it should be 6% injury or it should be 14% injury. So, Malad, this is how it is done. And finally, this goes to the central government where they will say all this to the central government saying it's only 1%, why 1% should be 3%. Central government has to finally issue a legislative notification imposing this duty. So, Malad, this is the danger of this kind of submission. Now, Malad, if your lordship turns up just 2 or 3 more pages, and I'm done. I won't take more than 5-7 minutes. Page 983. Volume 7, Malad. These are their submissions made. And it never really helps because your lordship can take it. There is a full answer on facts. the domestic industry methodology is not right. They made sufficient volume of sales in the domestic product. Normal value is so and so. Their costs and profit must be so and so. Point by point by point, full details are given by their clients. And in this, my lord, this runs all the way up to page 987. And your lordship will not find here saying, how do you expect us to respond if we do not even have the basic figures of injury? My lord, if it is such an important point, what would put it in the forefront? Saying without this, how do I even answer? It makes no sense. There used to be a very nice book called Natural Justice by Jackson. It was a small book. We used to cite that when in the earlier days. He used to always say, I remember a passage Justice Krishna had quoted, natural justice is not a bee in somebody's bonnet, nor is it a loose horse. But, natural justice is a principle of justice. You have to show, I was not given this, it vitally affected my case. Not something like I've shown you some asterisks, I've shown you some this, breach of natural justice. Yes, I have a full appeal on facts and law, but the writ court must be burdened with this. Then, my lord, please turn to page 1024. Now, where did the asterisk figure come from? Your lordship has para 136, Mara?
Yes.
That asterisk figure relates to H, just above 137. Hilosa Industries has submitted that man-made fiber industry operates on thin profit margin, and in the case of imposition of duties, company would have no other option than to pass on increased cost to downstream. It has also stated 30% duty margin will lead to 10 to 15% impact on PSF. Your lordship had that one?
Yes.
This is all polyester fiber. Then, my lord, the authority has noted all these. Then I read out already para 142, 143. And in para 145, sorry, my lord, to turn your lordship back to page 1027.
Yes.
On this, the authority says, based on the above, the authority notes the imposition of ADD would have an impact of less than 1% impact on the end product price, which it considers can be easily passed on to end consumers. Now, this could be wrong. Somebody could say, sorry, your calculation is wrong. This figure should not be 0.09, it should be 0.8, etc., etc. This then becomes your own industry is giving your production figures. Please note, these are not my figures. These are their figures. They have given these figures. Some of the figures, they may themselves claim confidentiality. And then you come to a court and say, these are not disclosed. You give a figure, you say, don't show it to anybody. And then you said, don't disclose it. And then when it comes to this, you argue that this is not disclosed. Then, my lord, please note, starting from page 1028, submissions made by other interesting parties. What my learned friend cited is in small Roman 9. That's the only place I have found, Marat, a mention of this. The authority has not disclosed essential facts to the respondents as required under Rule 16 and is contrary to the decision of the panel in Russia versus commercial vehicles. Manual of Standard Operating Procedure requires detailed disclosure of normal value with workings. These are my figures, Marat. These are not the figures he's talking about or his manufacturing figures. And we don't know what these are. These are all answered, Malad, by the authority. After considering all this, page 1032, the authority considers all the points. I'm not going to troubling your lordship with the details. Now, my lord, just see F at page 1033. This is why I'm saying, my lord, it can't be the way my friend has said, no facts are required, it's wrong. The domestic industry has provided prima facie evidence to substantiate existence of PMS. In SOK, burden of proof shifts to exporters to demonstrate it does not exist. It is reiterated government of Kuwait has issued a royal decree allowing two exporters from Kuwait group to procure key food stock at significantly lower rates. Now, my lord, this is the real thing. So Kuwait government is favoring its own manufacturers. It is giving them cheap feedstock because they have a lot of oil. Kuwait. Now, those are being dumped onto India. This is the sensitivity of the matter. Now, when the authority has considered all this and given detailed findings, I would, my lord, respectfully submit that this whole point of natural justice is what we call, my lord, a lawyer's construct. You pick up one point and say, look, this detail not given, that detail not given. If your lordship turns only to one more para, 1030, page 1037, 175, those asterisks will become very clear. Equate Group has disputed the 3.6% impact on PSF on account of anti-dumping duties and has claimed it is not aware of how MEG constitutes 16% of PSF value. The authority recalls para 137 of the final findings, where it is clearly mentioned that calculation provided by Bilosa have all been examined. All assumptions considered by authority for impact of anti-dumping are being based on assumptions provided by Bilosa. Landed price has been considered. This is for PSF. These are those asterisk marks. And then, my lord, come the conclusions. So, my lord, I submit that yes, the basis, what page 33 of the compilation, rule 16. The designated authority shall, before giving its final findings, inform all interested parties of essential facts under consideration, which form the basis for its decision. Now, my lord, how will your lordship assess whether a particular fact in a whole complex economic analysis of the impact of landed costs, of what it will going to injury it is going to cause, is it going to create increase in the domestic prices? What is the injury it is causing to domestic industry? Which is, how are these two to be balanced? Is a case made out for duty. What are the essential facts, my lord? Because it's not every little factoid which has to be given. Now, to assess essential facts, my lord, would your lordship not be required to go carefully into this order and to go into what is the core of this order and analyze the order? And isn't that what the job the appellate tribunal is meant to do? So it's no use saying the bench is not sitting, look at their roster. Your lordship will direct them to sit. This is their statutory duty. They are not doing anybody a favor by sitting and hearing these cases. And in fact, my client is interested, my lord. We want because we are suffering this injury day by day till the duty is imposed. Obviously, the importers want to play it out, come to the court, point out one paper, get it set aside, go back another 2 months, and another authority, then they'll miss one more paper, then come back, try their luck, then go to tribunal, then argue in the tribunal on merits, by which time another 1 year has gone, then they'll say, oh, this period of inquiry is stale. Nobody withdrew the previous complaint. Then it's sort of designated period of inquiry. In the meanwhile, prices change, economic conditions change, you start a fresh inquiry all over again for a different period. So, these are facts which your lordship will have to consider. So, Rule 7 is not under challenge. And finally, my lord, the Reliance judgment doesn't help him at all. The judgment is there, my lord. In I don't know whether a copy has been made available. My friend said he has a copy available for the court.
He read it from the quotation. It was
Yes.
quoted somewhere in the.
Yes. But I'll read out, my lord, that quotation said the DA claimed confidentiality from the appellant about its finding on the data supplied by the appellant itself. Obviously, Rule 7 cannot apply to that. Here, my lord, I pointed out it is below. So that's why I submitted, my lord. This is not a fit case for your lordship. Of course, we know your lordship's jurisdiction, whether planetary or plenary. Of course, the court has jurisdiction under 226. Your lordship's jurisdiction, even to go into facts, is not a jurisdictional bar. This is how the court exercises judicial review. The court has developed a discipline by which it acts. And I would submit, my lord, in matters of this economic complexity, where the legislature has created a mechanism. Please understand, my lord, this is very important. Under the GATT, it is the prerogative of the Indian state to impose a tax. Under the GATT, we have said we will do through a transparent mechanism. Under the General Agreement on Trade and Tariffs. That is why, my lord, it's very unusual for a customs duty to be on the basis of such a finding. So we have created a system. The courts, as far as possible, have said, try and make it as quasi-judicial as possible. But the appellate tribunal is a part of that machinery. What your lordships are being asked to do is interdict that machinery. If your lordships just see, and I'm finished with this, section 9C once again. What does the law provide? Why is the law? This is not a normal case of a person being called for a lease and adjudication in the general sense. Yes, of course, it's a lease between domestic industry and the importers. But the statute creates a structure. And that structure, my lord, begins from section 9A. It's page 4, my lord, of that compilation, if your lordships have the compilation at hand. It says where any article is exported by a producer from a country, territory to India at less than normal value, then upon importation of the article, government may by notification impose anti-dumping duty not exceeding the margin of dumping. For the purpose of this section, margin of dumping means the difference between the export price, then, my lord, all that is defined. Now, normally, my lord, these are taxes. There's no question of this is purely legislative in character because you're imposing a tax. Where this comes in, then, my lord, subsection 2 is the provisional duty. For purposes of this, my lord,
Yes.
the mechanism has been created in subsection 2. Your lordship has that? It's in the middle of page 5. The central government pending determination according with provisions and rules of the normal value to any impose on the importation any anti-dumping on a provisional estimate, etc. If such margin is the anti-dumping duty, these are provisional. Then, my lord, 2A notwithstanding notification, etc., etc. Those are. Then section 4, subsection 4, anti-dumping shall be in addition to any other duty charged under the Act. So this is, my lord, pure tax. Now, where we come in, my lord, is subsection 6. The margin of dumping shall from time to time be ascertained by the central government after such inquiry as it considers necessary. And the central government may by notification make rules for the purpose, and without prejudice to the generality, such rules may provide for the manner in which the articles for any anti-dumping duty may be identified, the manner in which the export price and normal value and the margin may be determined, and for the assessment and collection of such anti-dumping duty. Now, my lord, finally, subsection 7, once this duty is notified, it is placed before Parliament. So this is purely legislative in character. Now, but we have created a machinery. And in that machinery is section 9C. So, my lord, this is not under the General Customs Act. An appeal against. Now, today, my lord, please appreciate one thing. This is only the central government determining and making a recommendation for the imposition of duties. So you're determining margin of injury, you're determining normal price, etc. It's a determination. These are antecedent facts to the actual imposition of a tax. The government can still say, I'm not imposing the tax. In this mechanism, in 9C, it says an appeal against the determination or review thereof shall lie to the sestat in respect of the existence, degree, and the effect of any subsidy or dumping in relation to the import of any article. So, Malad, the tribunal itself is like a reviewing, is like a primary authority. You have the government's determination, you have the tribunal. And that is why I said, Malad, this natural justice is not like a silver bullet, that one document not given, everything falls away. You have to see what is the impact of the document. Suppose something was wrongly withheld. The tribunal says you had more than enough material to come to the conclusions even if this was withheld, no injury was caused. Then there's no breach of natural justice. So, I submit this is not a matter of that kind where it's an adjudication, some evidence is kept behind, you don't disclose the evidence, how do I rebut it? These are complex economic calculations. And let the tribunal look at it. Let them decide. Your lordship will direct the tribunal to hear it early. That's the point on maintainability. I've done, unless there's anything more I can assist your lordship with.
May I,
Only one thing, Mr. Salim, the judgment which Mr. Mukherjee has relied upon, to include the question of law as a part of coming to your lordship, 220. Your lordship can have a look at paragraph 8,
Paragraph 8 of which part?
God great sir, I'll be
Para 8.
That part mean
May I be excused, Malad, unless there's anything else I can assist you?
Yes, yes.
Deeply open.
that part, what appears to be formal petition. Whether a certain item falls into the statute, raising a pure question of law, and an investigation of the facts is unlawful. This is the word. But today, Mr. Mukherjee has published parts of it. One is for the judgment admission with regard to the fact which is now disputed, we need rejoinder. It is converted out from 270. Today is saying something very conscious. He does not in any way say anywhere that the recordings made by the authority is wrong or is not proper. So, this still makes a question of facts. So, therefore, it would not fall under this point. Second, if you lordship kindly see the one worldful, I cannot join issue, it's a question of principles. Jurisdiction, made this point of two things, on an adequate point. He is saying that the authority did not have the jurisdiction, but he has gone for the authority. He has participated in the jurisdiction. Today, what he is trying to say, that it has acted wrongly, but he cannot say today that it does not have a jurisdiction. Because he has, at every instance, given his entire defense there. And he has referred to his namesake, judgment, with a separate spelling. Wrong spelling. Sorry. Wrong spelling. He was referring to paragraph 36.
39, 32 and 39.
32,
39. Yes, 36. Reason.
And he has referred to Siemens, my lord. Now, second, when authority makes an order in excess of quasi-judicial function, it must record its reasons in support of the order itself. Your lordship has gone through the order, my lord, changing to so many pages, my lord. Can it be said it's a order on reason? Whatever point Mr. Mukherjee has taken today is on the point of the question. Whether it's a domestic industry or not, my lord, that also becomes a question of fact. Because my lord, in his, my lord, in the recording, it is found what is the percentage reliance in the market. My lord, if that is a finding that it is not, it's wrongly found that it is not a domestic industry, my lord, then also it is not a question of fact. It is not a question of law. My lord, what do you mean by question of law? It will not require any fact to be considered. First thing, Mr. Mukherjee is asking you to open up the fact. And my lord, with regard to Philosa, my senior has already pointed out, my lord, that Philosa has been just kept confidential. And my lord, Rule 7 provides that I will have to keep it confidential. I may not if I say that it is not, but it is within jurisdiction. Rule 7 and its applicability of that asterisk, my lord, is an action within jurisdiction. It's not outside jurisdiction. You can consider this, I have wrongly done it. That does not mean I am assuming a jurisdiction which I am not entitled to. Rule 7 says anyone giving any document, any particulars may ask you to keep it confidential. But they have done that. They have given the confidential data, and they have said that don't publish it. Once they act in terms of Rule 7, and then why did I act in terms of Rule 7 of data which does not relate to them? And last, the authorities in Delhi, the proceeding was in Delhi. Violation of natural justice, if any. No Baji point. But if I am a purported association, then then to that extent, no, it is a question whether your lordships will open up the doors of 226(2). Under which provision is he coming here? Because the authorities are before the Delhi High Court. He has to make out that case that an integral part of his cause of action is within. The only thing is this fact finding or final disclosure, which again, final disclosure, the orders which he is asking for are all beyond.
There is no pleading. How cause of action?
And only he said, yes, kindly see the pleading. I am on his pleading. He says that kindly see the pleadings. Now kindly see, my lord. But first, my lord, 77.
Paragraph.
It only is an শুনেছিলাম স্যার এখন সবাই নিচ্ছে আমিও নি আমার appearance
Paragraph 77.
No, sorry, madam. 77, madam.
Paragraph 77 or page 70?
No, para 77, madam. It does not run into so many. Initiation notification was to and did operate all over India, including in the state of West Bengal, particularly the registered office in Calcutta. And the factory of the petition number 1 is situated at Haldia. How does it matter? Further, the petition number 1 obtains delivery of MEG through waterways and unloading of shipments at Haldia port. But this is not the cause of action, but which is required for 226.
Rights are infringed within the
territory. Which right?
Whatever rights he will canvass.
Rights which he is going to canvass, is with regard to the authority and the finding by an authority.
No, he'll be visited by the dumping duty. Duty. That will visit.
Dumping duty will be imposed from there.
It will have effect here.
Matlab, that is what Poland Banerjee and all other judgments say, that issuance of a notice or issuance of any final adjudication will not give you cause of action. That doesn't, then matlab, that would have, what would happen, matlab, then it creates a mayhem. So when he's saying this, these are not causes of action which are related to his petition. This order, whatever the order is, does not affect his waterway or bringing in the MEG, the delivery of the MEG doesn't. It's not an essential part of the cause of action. But just by making such pleadings, it does not bring in. Then that would create that everyone can come before your lordship from any other state and vice versa. 226 has been given, but in a limited way, your lordship do not just give it a very wide interpretation, because kindly appreciates he is challenging an order, quasi-judicial order of an authority in Delhi. On one hand, he says, one kindly appreciates that the authority says that. That's in Delhi. Insisted not taking up matters. Go to Delhi High Court. Why here? Because Sestat will also be under the Delhi High Court. Today, my lord, if Sestat is not working, my lord, with humility, kindly does not take me amiss. But the power and the authority on the Sestat will be that of the Delhi High Court. Per se. Because it's within the jurisdiction, territorial jurisdiction. And because this is not the first time, number 3 had gone to Delhi High Court. The first one, let's remand it over. But the point is, my lord, today the designated authority or whatever the authority that is in Delhi.
Very good.
My lord, just keep a note of, my lord, page 961, my lord.
Page 961.
Volume 7, my lord.
Yes.
My lord, here your lordship will find there's a finding that RIL, their submission.
Yes, please.
Para 26, my lord.
Yes, 1 minute, Mr. 961. Yes. 961.
Para 26, my lord.
26. Yes.
And this is their what is the order? And this is part of the post disclosure comments, my lord. Yes.
Paragraph 27.
26.
26.
Yes. Kindly see the users understand, second sentence.
The users understand.
Understand that during the POI, RIL imported a total of 14,330 metric ton of MEG. And now in their petition, my lord, at para 46, they say RIL had imported 1,80,000 tons. And they have not disputed this in the manner it is required to be disputed if it's a wrong recording or submission of that's their document. But I am only trying to show, my lord, another aspect, my lord. Contradictory statements, reference to confidential data of a third party, these are being made as grounds of natural justice. And this is other than, my lord, because he says naturally this is there for your lordship has jurisdiction. We says that, but why territorial? Nothing has come forward. But this is what I'm trying to submit. Please.
My lord, let me start with the last point first. My lord, one of the cases relied upon by my learned friend, my lord, item 6 of their compilation, page 91. I rely on that. They have given it as a compilation, so I'll rely. So you ought to have it. Having no, I'll rely on it now.
Then I will also
Yes. Go on, I don't mind. Yes. Now, my lord, kindly come to. Yes. Kindly, my lord, have a look at India Paints, my lord. They have handed this up. I had no correct. I also handed it up. Yes. So now I will show exactly same point taken with territorial jurisdiction rejected. My lord, paragraph 27. My lord, page 104 of the compilation. Kindly, my lord. Yes. Para 27, the heading you will also will find. My lord, is territorial jurisdiction. My lord, I don't want to, my lord, go into too much detail on this. In fact, even Mr. Salve, my lord, thought it fit not to take this point. But my lord, kindly come, my lord, straight away, my lord, to para 29. My lord, page 115.
Para 29.
Yes. Now, my lord, 28 onwards, rather, my lord, rather than 29, 28. As would appear from the provisions contained in section 9A of the Act, Rule 5 of the rules, read with notification dated so and so, the designated authority upon publication of such notifications had invited all interested parties throughout the territory of India to offer their comments within the time specified therein, not only on the scope of consideration of the products under consideration, but with regard to the exclusion thereof, and also with regard to any information that the party interested may make available. The aforesaid initiation notification was published in the Gazette of India and was intended to operate throughout the length and breadth of India. That's number one. Petitioner has its registered office at Calcutta. The claims upon going through the above notification had participated in such to its the preliminary objection of the petitioner with regard to so and so, petitioner also contended, etc. Then physical characteristic, then my lord, disclosure statement, 29, para 30, disclosure statement. Then my lord, kindly come to para 31. Producer would also demonstrate in were offered an opportunity to offer their comments. The above disclosure did not constitute appropriate disclosure, etc. Then, my lord, arguments, my lord, advanced by Mr. Sharma against, my lord, territorial jurisdiction and, my lord, natural justice. Then para 34 is very important. Kindly have a look from the PDF that not only the investigation initiated by so and so was to operate throughout the territory of India, but all the interested parties were called upon to provide the inputs primarily with regard to so and subsequently at the various stages of the investigation, which provide rights to receive necessary particulars, etc., not limited to objecting the claim of confidence. As would appear from the petition, final findings and levies are to have a direct impact on the business of an interested party, including the petitioner, which has registered office at Calcutta and has been operating from Kolkata. As such, it cannot be said that no part of the cause of action had arisen within jurisdiction of this court. In fact, the effect of the initiation notification, disclosure statement, determination as reflected in the final findings and the levy are to have a direct impact, and the effect thereof was felt by the petitioner at its registered office at Kolkata, within the territorial limits of Kolkata and within. Then, my lord, Mr. Mitro, my learned friend, Chamber Senior, had taken the territorial jurisdiction point. Yes. Then, my lord, kindly come to, my lord, para 35, my lord, page 119. My lord, it starts at 118, kindly come to 119. Last 10 lines of that, without going into the issue that a pointer is taken as and by the statement made has to be taken to be true and correct. The Honorable Supreme Court held in such case, even by accepting the state, no party has arisen. Such is not the case here, the above judgment. That was ONGC. Then Kusum Millard is considered, which dealt with Article 226, etc. And then Millard, the Madras High Court decision. And Millard, ultimately, the court held Millard that this Millard issue Millard court had jurisdiction. And Millard, all the necessary pleadings, Millard, apropos this, Millard are here. Now, Millard, second Millard is the other Calcutta High Court decision, Millard, which was Millard cited. Millard, that's 2012 SCC online, Calcutta 8071. Now, Millard, your Lordship will find that Millard, the learned counsel Millard, who is appearing Millard in the next set of matters, was Millard appearing in this, and Millard, thanks to him, Millard, who's quick to Millard, point out that the definition was different. Kindly have a look, Millard, compilation page 16. This is a 2000, based on 2011. Millard definition, Millard was different. Millard, he was assisting Mr. Bajoria, Millard, Mr. J.P. Kehta.
Page 16.
Yes, Millard. 2B, this is what I pointed out, was an amendment which happened. The notification under consideration, Millard, initiation, at that time, Millard, that bracketed portion only, Millard, was deleted. Only is not there now. And second, and this is very important, my lord, what was argued by my lord Dr. Chakravarti was, importer is the definition given in the Customs Act. That is what should be the interpretation given to my lord importer, my lord, as appearing here. And my lord, what was argued was, definitions, my lord, take, my lord, their meaning from the context in which they are used. And this was, my lord, apropos, my lord, anti-dumping. So therefore, my lord, what the learned single judge had held in that particular case, my lord, was, my lord, to go by, my lord, the definition of the Customs Act, which, my lord, was rejected. The lordship will find that, my lord, page 71. My lord, last, my lord, paragraph on that page. While reading the aforesaid, my lord, that's quoting my lord,
Yes.
reading the aforesaid, unable to accept the meaning in the given, it seems to us, learned trial judge has adopted the definition of importer in Customs Act and has applied the meaning in common sense. We think this cannot be done, even considering contextually as argued. This was the issue there. First, the definition section is different. And second, my lord, that it was, my lord, argued in the context of the Customs Act rather than, my lord,
So
anti-dumping.
even if it is a minuscule import, he is an importer.
Correct.
In terms of the
Correct,
present,
correct. Well, that's a decision. It's a question of law and interpretation. I'm not going by calculation here. Now, my lord, what my learned friend has argued, everything is made available. Now, my lord, therefore, all this story of natural justice, etc. Now, I've shown your lordship what was not disclosed. My lord, I had given data. I had treated it as confidential. When you're doing a working, you can disclose it to me. That was the exact situation in Reliance. I had furnished data saying it is confidential. You accepted my confidentiality. I have no problem with it. But when you're working out to find what my raw material price would be and what it would, how it would affect my end product price, that data you can give to me. You can't claim confidentiality on data supplied by me. That is what Reliance is. The data that I submitted, on the basis of which you come to an overall impact of 3.6% on my raw material price and 1% odd on the end product, is not data by domestic industry. I am not domestic industry. All the tables which have been shown to your lordship, where the calculations are, confidentiality you've accepted, this is domestic industry. Sorry, no. It's the data which I have given. And now, my lord, why I say it's important, why this needed to be given, because I must know what calculation has happened. And this has to be given before the final findings. That's, my lord, rule 17, which I read out. Essential facts before the final findings, so that I have an opportunity to comment on it before you come to a final finding, before your recommendation can be acted upon by the central government. And why is that important? Now I want to show your lordship, my lord, the appellate provision. I'm very glad, my lord, that, my lord, we've been led to this, because everything can be sorted out according. I have it. My lord, kindly take section 9C. Customs Act of Calcutta. Come on, take out the Customs Act.
Yes.
Now, my lord, kindly see, my lord. An appeal against the determination or review thereof shall lie to the customs so and so in respect of the existing. I've read this before. Everybody's read it. 5 has also been read. Now, kindly see 4. Subsection 4. The provisions of subsection 1, 2, 5, and 6 of section 129C of the Customs Act shall apply to the appellate tribunal in the discharge of its functions under this Act, as they apply to it in the discharge of its functions under the Customs Act. Now, kindly have a look at, my lord, what is left out. 129, my lord, is the appellate tribunal. My lord, 129, my lord, is the appellate tribunal.
Yes.
Now, my lord, kindly see what has been left out, my lord. My lord, kindly see. One 129C, it's there or not there? 129C, my lord, kindly have a look.
Yes.
Now, my lord, the lordship's notice, my lord, subsection 7. It's been left out. Now, what does subsection 7 provide? Compelling production of books of account and other documents. It's not there, it's not there. So in this case, if an essential fact, which is what? The working sheet on my figures.
And if they had supplied it to you, how would have
In the appeal, if I didn't agree with it, I would have brought it up. So that's the short point on what, my lord, I didn't say that whatever they claimed confidentiality on. My lord, one is party confidentiality. One is authority confidentiality. Party confidentiality, I'm not making an issue of. I ought to have, I haven't. Those are the passages which have been read to your lordship. But the only issue I made was with regard to designated authority not giving me the working sheet on my data. to arrive at a finding. It's a crucial, my lord. It's not any old paper. It's not just one paper. As Mr. Salve, my lord, attempted to, my lord, trivialize the point. It's not. It's very, very important, my lord, for, my lord, my lord, consumers. I'm not domestic industry. If you worked on domestic industry figures which are confidential, I can't complain. I have not raised that issue then. That is, my lord, the issue which I pointed out, because they say,
And the chart which was placed before.
yes, my lord, they don't relate to, my lord, my data.
No, and the other one which relates to PET, is it not yours? That was, I think, page 1024.
Yes, stop that. Yes, I'm coming. I'm grateful to my lord.
One 1027.
Yes. Below, sir. What about me?
And page 144.
144. 104.
Sorry, paragraph 144, 1027.
1027. Yes. Who has submitted this data, my lord, with the greatest of respect? Not what I
Domestic.
submit. Yes.
So not on your.
No. Not on my data.
So the data which you have submitted and the calculation which you have done, has that been reflected upon?
No. I need to know what, because you are considering the entire industry. You have to consider everybody.
Not even a one-line conclusion.
No. My lord, I'm dumping margin table and injury, which I showed your lordship. My lord, that's 996, where one would have expected this, and 997, 1020. Injury margin table. These were the other tables. Sorry. No. My lord, that is, my lord, the real point.
So the error.
Kindly take page 1970.
973.
You got that? You lost this kindly take subpara 8. Subpara 8. To operate sent importer questionnaire to the following known importers, users of the subject goods in India, calling for necessary information in accordance with Rule 64 of the AD rules. Now, along with this, mother, kindly take the questionnaire and the answer to the questionnaire, which starts at page 448. These are our answers to the questionnaire. Kindly, I am skipping over. Kindly take, mother, the page 4. I'm so sorry, mother. I'm so sorry.
Page 448.
448. Kindly take, mother, page 450. Mother, where we give answers to the questions contained in the questionnaire.
Five zero.
448 it starts.
Yes,
Kindly take 450, question number 6 and the answer to the question number 6.
450, yes.
Question is that please give the details. Now, this is what the designated authority asks us to give details. Please give the details of all your units linked to the product under consideration in India and indicate clearly the role or operations performed by these units. Response: the company has 2 manufacturing units in India. One is at Holdia, West Bengal, another is at Karnal, Haryana. And we have given the addresses of the plant. So, my lord, the manufacturing activity of the unit under consideration, that is IVL Dhanseri, the petitioner, was under active consideration of the designated authority. And so, my lord, this plea that this court does not have the territorial jurisdiction or lacks the territorial jurisdiction, well, that plea does not stand, because even if, may I quote, well, I am not citing the judgment, this one judgment of Rajendran Chingara Velu, where Justice Ravindran, speaking for the bench, held that even if a minuscule part or a fraction of a cause of action arises within the jurisdiction of this honorable court or any court under Article 226, well, the jurisdiction would be attracted.
Yes, that has been echoed in Kusumingots also, saying that
Kusumingots also,
although that does not become a determinative factor because of forum convenience, but
yes,
it
yes.
does give rise
Yeah,
to a cause of
And the
action. And
question is, what is
Just 1 minute.
also, sir?
Just wanted to add one thing. My lord, all the tables your lordships were referred to, which your lordship drew my attention to now, are all in the final finding. I asked for this.
prior to the
Yes, and the
first
and the
round,
duty is to disclose then before the final finding.
because otherwise you don't
Correct,
get an opportunity to
correct,
deal with
before
it.
the final finding. That is the point.
Grateful, madam. Grateful.
They don't have to go all the way back. They just have to give me that. I proceed further thereafter, my response to the disclosure statement and do a final finding of fact. This is the point.
944 disclosure statement.
944.
Quoted.
That is on disclosure he has asked, he has got it. He asked for it, he got it.
It's the same chart, my lord.
Give me the same chart. One thing, I do not understand, my lord. First of all, whatever he's saying, kindly goes to the previous document. There is no support of all these things. You have to say when violation of natural regulation. Second, when he's saying that no, it was not provided, I am showing. Then now he's saying that no, it is the same table. So what? We have said it was not supplied.
I have said it in response to this, that you haven't supplied it.
In response to this was the
My
document.
response to the disclosure statement. As per
Disclosure.
You should have said so, I've disclosed it. This is the statement. I have not said.
Disclosure statement, they have only been on PSA. When your document goes to that document, you have to find the same lawyer has filed for both. Sir, as well as this company. But the only objection was with regard to PSA, not paid. PSA is the wrong here. No, it's not. PSA and PSA are different. PSA, Indian manufacturing process. PSA when you supply and when we have paid. That is why this is the reason it should go to
Very well.
that is why you are actually fine. When you have been paid to it, it was designated as creation of separately. Sir, and see this. Well, this is now finally going to this end.
I'm keeping it one more day in the next week. I'll go through the papers. I may have some questions, I may not have. On that day, I'll conclude hearing.
Thank you, sir. The next matter. Serve the copy. I'm your person for information and application.
Please add them as parties. I'll hear it out as well. Very well. Very well. I'll just finish that and come to this and pass an order of addition. The one which was being taken up. With that, if you listen, heard Mr. Mukherjee, learned advocate appearing for the petitioner, comma, Mr. Salve, learned advocate appearing for the respondent number 3. Respondent number 4. And Mr. Rai, learned advocate appearing for the respondent number 3. 3 and 4. 3. Yes. Mr. Mazumdar appeared for respondent number 4 and 5 and has also made his submission full stop. Parties have been substantially heard. List this matter once again for further hearing on. Please give a date so that on that day a long hearing may not be required, may be required. I don't know. I'll also go through these papers. Give me a date so that it will be easier for me, because that day then. No. I'll go through it. Any day next week. Then I'm giving it. I'm giving it. So Mr. Mukherjee's convenience will also be required, all of it. Okay. 28 will be a Friday. Friday will be difficult because we'll be having a different. Even above the 4. 26. 26. Very good. 8 next matter लिख Not the faceless. Then I'm admitting it as has been admitted by other single benches and directing stay as stay has been directed. Very well, I am saying it till such time because unnecessarily what purpose will it serve? If I just admit it, then that order can also be passed. It is the same thing. I pass that order. No problem. Why not? Why not? When was the notice issued? What is the date of the notice? Second June. How can it be 20? Your writ petition is of 20, that's a 27 December 2024. How can that be? No, writ petition affirmation date is something else written. You see what you have written in here? Below. Solemnly affirm before me on this 27 December 2024. Not corrected here.
But only that one forty for participant and it is not the assistant after how you are going to do this because nobody knows whether Supreme Court
Proceeding will let the proceeding continue. You will be prejudiced only when the order is passed and communicated to you, not before that. What is the problem? Yes. That is on merits. So let the proceeding continue. Assessment order passed will not be given effect without leave of court. It is same thing. You will not be prejudiced and the proceeding will also continue for some time till the assessment order is passed. It is as good as very well. I am not going on merits at all. It is being entertained only on the jurisdictional aspect. That is why assessment order is not being given effect to. It is the same thing. It is the same thing. It is the problem. That very well. I'll pass that on. Then the assessment order will be passed and served also. But that is more harming to you. That order is harmful to you more. Because then in that case, assessment order will be passed and communicated. Mr. Bhattacharya, I am because in the famous Sessions matter, there has been an order. I am saying it. Listen. The petitioner assailed আচ্ছা ওখানে আরো রেকর্ড করে দিন যে এই মিস্টার ভট্টাচার্য is 19. 19. Yes. It's 21. This 22. Yes, Mr. Chakraborty. What is this order? Why have you challenged it after so many years? He's right. 2018 order you are saying. The order is dated 2nd of August 2018. What is your explanation for 6-7 years delay? Paragraph 18. Before that, what had happened? Reform means I cannot get this. Reform means what? There. The committee was without management. How will the committee function then if there is no management? For 6 years there was no management in this. Then there must be nothing in the committee for 6 years. If there is no management, what will remain? But it will take away everything. How will this explanation suffice? If the company is there is no management, if the committee has very well, Samavai Samiti means cooperative, right? If the cooperative is without management, it does not take any step for 7 years, all of a sudden it will rise, come to court and then seek orders. That cannot be done. This explanation is not sufficient. It has been reformed means what? And who is recognizing this? If your registration itself has been cancelled, all these days what had happened? For all these days what had happened? For 7 years, nobody was there to take stock of the company, of the committee. Then suddenly after 7 years, it is constituted. Doesn't make sense. It's a lot of time. If it had been 6 months, 7 months, 1 year, 7 years. 7 years is a lot of time, sir. There has to be something for me. It's almost more than 7 years. No, but you have written the petitioner had filed last return in the month of August, in the month of for the month of August 2018. So that is not prior to cancellation. What you say? Cancellation. So that means in 2023 there was somebody at the having control of the Samiti. Then also there is delay of 2 years even there. And before then your submission that there was no management at all again becomes false. It is contradictory. He's right. Because then 2023 there was somebody who was there. In 2023 who could have come. No, no. You have deprived yourself from business. What can we do? You should have come earlier. Can you apply afresh? What is the law? Is it? For all these days, again, the interest will definitely rise for whatever it is. The amount will not be that only. You take instructions from this and don't say on your own, it is more than 1 crore then. Yes. Okay. Then on that there will be interest for 7 years. You have any order where after 7 years this order has been passed? No, but here it was a better case. He had filed a reply, come to court within time. Your case is not that. You what no allegation? This is an order. There must have been something. Show cause notice is there, case 21. So you say you have not obtained by means of fraud. Have you said that? If there is a single line, so you don't have any obligation to reply to that. That is not an answer. You may say that yes, it is a one-liner, it is vague, therefore I can't understand. But you will not reply at all and then come to the court after 7 years as if the court is obliged to pass an order in your favor. That is not right. That is no submission at all. Please do that. Learned advocate You have to file an application for amendment. That is why time was granted last time also. Took a week to adjournment. लिखे नहीं. A prayer. Oh. Bereavement in the family. An adjournment is prayed for on behalf of the seven. Yes, Mr. Mukherjee. Banerjee. Banerjee. Yes, sir. 37. Yes. What happened? Illicit case. Huh? Very well. Huh? 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 So what did you do after that? Very well. Then, impugned assessment order, you don't have any avenue of appeal. No, but against the order, you don't have any appellate authority. So appellate authority is there. Why should I intervene at this stage? Show me. Show me. Which is the order impugned? See? See? Number 20. Hundred 20. Yes. But this is a factual dispute. How will the High Court go into this in this petition, sir? You are challenging this order at page 120. What is this at page 124? So-called notice under section 73. What is all this? Where is the last order which you are challenging? On 22 is the last order. The back and this 76 is supposed to correction from 124. This is for a different year. Year is what? I have not been able to understand this. What has been taken 2 times? But this is to be considered by the appellate authority. Go before the appellate authority. How can the writ court go into all this? Appellate authority, you make them understand, because how will I also understand whether factually it is right or wrong? You are saying it is double jeopardy. They may have some answer. Where have they charged? Show me. Show me from page 120. Where? Here is page 120. That is your return. Please read on. But sir, that is what I am telling. These are factual things. This cannot be ascertained by the writ court. It has to be ascertained by a fact-finding authority. You have to approach the appellate forum, which is why appellate forum is there. Go before the appellate authority. Say this. Why writ court? How will the writ court entertain? Adjudicate all this, whether you are right or he is right. These are all factual findings. If it was a question of law, I could have answered. But this is a factual thing. Yes, please. How? It says it's turnover of sale. Sale also will be exempted. Where? 101. One minute. You read 101. 101. Yes. Yes. The following services 1, 2, 3, 4, 5, 6. Where is that? Convening service in hospital? Show me. 105. Yes. Not conservancy, it's sanitation conservancy. Providing it only to a hospital will not do. You have to be entrusted, which is service which is entrusted to a municipality. It has to be in respect of a particular area. To one institution you are providing, therefore you will become a municipality. Right. No, no. Whatever. This. No, sir, it is not such a jurisdictional. It is not such a jurisdictional error where rich court should intervene. No. Any other point? Where is that tender? Show me where that tender is. Is 76. So they say you have not been able to produce the work order. That is why. That is the finding. Where? Not before me, before the authority concerned. See what they have written. As per the documents, he has a works contract of such and such, but in the database, no such records are available. No documents in support of the work contract has been produced. So how do you contradict this finding before a writ court? That is why you go before appellate authority. What is your fun in coming to the writ court? '23. 1122 to 1123. Yes. No, no, sir. You go before the appellate authority. I have heard you for your satisfaction because I wanted to see whether there is something. 51. It's 51. Twenty-one. Twenty-one. The first notice was at page. The first notice was at which? Given. So the period is not exactly the same. No, no. Some period overlap. Yes. So this is actually 2013, 12 to 13, 16, 17, and this was 12 to 15. So 16, 17 was lacking here, 13, 14 was lacking here. In the first one. No, 13, 14 was there, 16, 14, 16, 17 was 15, 16 was not there. Up to 15 was there. Why do you say this is without jurisdiction? Achha. So which one is without jurisdiction? 5, 6. Why this is without jurisdiction? Why do you say it is without jurisdiction? Yes. Only 57 or 57? Reply, this is the reply to the first proposed notice. Paragraph 2. The first one. Proceeding. Page 144. Yes. Sorry. how has this point been dealt with that you have already issued a show cause notice about? Yep. Yes. Issued in respect of same period. The issues are not the same, or the and the first notice? You show me the issue here in this notice. Show me that. Show me. 256. What is there in the second one? Mr. Bhattacharya, how is it said that the issues are different? The issues are all regarding to taxability of services. Then how can it be said that the issues are different? If this point is sustained, then in that case there is cause for interference. If this point cannot be sustained, then he'll have to approach the appellate forum, because this is the only point. You cannot issue a notice to show cause and then adjudicate on the basis of that on the self-same issue which is already there under consideration before the same authority or before the authority which is part of the same respondent's department. So, how do you say that these notices are different? Prima facie. 344. Yes. Five point three. Yes.
What the previous governing financial year filing for bond issued by the action company and another I find that denominations can be used for different issues according to the same period. I find that referred denominations have different issues with that of the present demand.
That we have said, but how they are different? How?
Was considered, my lord, after reply filed by them, after they went to the appeal, 2022, the order was passed. 24. Today they come with this petition. In the month of 3rd of June or 6th of June, I have to observe the letter which was coming along with the order.
Black.
Only black.
In my copy, nothing.
We are not visible. This copy also not visible to us. And my lord, first thing is that, my lord, the address has been changed.
3rd July 2025. That is handwritten. What about the postal receipt might contain this? You check it for yourself. I'll not be disbelieving you. So that has to be clarified, Mr. Bhattacharya. When?
From the order itself, it is clear.
That I have read. Order does not clarify. Order clarifies what it is, what this notice, that there was a different issue and what was the issue involved in this. But how this issue which is involved in this cause is different from that has not been explained. If you can explain that, it's well and good. If you cannot explain that, then this will suffer. When should I see
it? Next week.
Very well. This petition Another respondent? Then let it be called on, not like this, because all parties are not there. Let it be called on, then you make your submission. Very well, let it be called on. It may be so that he wants to appear today and the matter has been taken out of turn. That's not how we proceed. Let the usual course be followed. Once we reach, we make the submission. Lead matter. Yesterday, which lead matter did I take up? Yesterday, 5 matters were there, which were placed on 26. I don't remember. Very well. An accommodation is paid for on behalf of the petitioner. Order copy. these persons. Juristic personalities, they have their separate existence, legal existence, no natural existence. They act through natural persons. So the act done by juristic personality is actually an act done by the natural person who is at the hem of the affairs of the juristic person. So therefore, the penalty that is visited to the natural person will definitely be more than that of the juristic person. Juristic person will be paying out of the kitty that is there for the juristic person's use. But since the natural person is deemed to have maneuvered all that, he will be visited with a greater penalty.
And it's not that I have deleted 20% of users.
What would you do with the division bench? Where is that? Which page? Two 37. Yes, 237. Because see, there are two things which stand in my way. Page 237, second paragraph. Your penury has been noted that it would not be possible for you to put up this statutory pre-deposit has also been noted. And then it has been said that it's no ground. But that is exactly which the report didn't do. Whether I can waive off penalty that is statutorily imposed. In view of this order of the division bench, I think I cannot. As a single bench, I will be powerless. This order you can get from the division bench, not from the single. This order can, I cannot bypass this order and pass something which. That I understand, but there is a problem here.
I can't go front, because I can't go back, I can't go sideways. And I'm triangulated by this penalty. The company is got free. The company is directly within the city. How the working combination of behavior got free. Because the department has gone into appeal before the authority report, not under research. Because that appeal is governed by the circular which governs the litigation policy. Over there, present 1 crore is card by so that has struck in another thing of indirect influence. In light of that, today when there is no demarcation scheme or penalty against scheme as well, good or bad, I'm not. I'm subject to 23 crore penalty. Now, this penalty, bad penalty again, that has to be decided when the papers of the case open and that's are gone into. But the criteria of the just something I wanted to bring forward. Demand was exercise. Demand of duty was exercise. Question was on personal penalty. Plus, in the actual matrix of that judgment, now this notice is no
Where is the provision for pre-deposit? Yes, statute. So it's 129E, not double E. What is the total penalty imposed upon the company?
Delhi High Court has said, you pay penalty 7.5% of the company. Over there, the penalty of the company was 2 crore, personal penalty of the customer was 5 crore. Delhi High Court in writ procedure said that this appears to be disproportionate. They pay that this may be involved in the alleged evasion, but still it says that the penalty is disproportionate.
Where is the Delhi High Court? No, I have it. Then if you have given it, I have it.
Satish Kumar,
Yes, please.
2020.
Yes.
Let's just come to that.
Yes.
I have gotten judgment only to show that there might be an amicable too, which does not cover whether the lordship also or the bank also carried by also the sector. No one is prejudiced. But when I think 7.5% of 23 crore, especially when there is no demand or financial company quoted, that puts me in a prejudice. The problem is on the land position, it's said to my lordship that I will extend the time. Because the problem will be, I will not follow the rule time. I try to appeal against it. It will get stuck. Again, I'm in the case. Again, and no better. I just said I say to get the freedom. Not will I get a judicial or saying that what I'm doing is correct. And some people will try to recover. If the people God knows how to recover, they try to attach anything that I have, try to attach my anything that can access retirement. That's all it's done. But I here is the most amicable. So local people is not as amicable as this, but Delhi High Court is the most amicable.
Very well. Yes, sir.
Unfortunately, no, we have to pass the obstacle of being there having no alternative remedy. Second, there has been a violation of natural health. Neither here nor there we cannot. We could not do. And thereafter, he has this impediment to getting the things affected, that there has been any violation or receipt against it is a good presidency that we have this order dated 14 July 2004. Page 139 to 172. 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 139
Yes.
On the petitioner, here, the penalty is in page. Personal penalty is page 170 of the order,
170.
170 of the petition. 30.2, I hereby impose a penalty of 67,14,232 to Sri Naveen Goel, Director, and Sri Praveen Goel, not my mistake, Praveen Goel, Director of Beriwala Intech. Well, I found, no?
Yes.
And Sri Naveen Goel, Director, Christian Up Global Pte Limited, Singapore, and Starlight Polymates Malaysia, brother of Praveen Goel. I also imposed penalty of 15 crore each on Praveen Goel, Director, Beriwala Intech, and Naveen Goel, Director, Up, and several under section 114 AA of the CA Act. Now, my lord, this has been, we have already come to the report against that order, that is in page 174 to 199.
Yes, that I have seen.
And place the order. This
02.
has been considered. Page 202 of the petition.
Yes.
The petitioner has assailed an amplification order passed by the Commissioner of Customs Court, Kolkata. Learned advocate for the petitioner has submitted that although the impugned order is applicable, the repetition is maintainable against the impugned order in view of the fact that principles of natural justice has been violated while passing the impugned order. He has submitted that the customs authorities did not issue any show cause notice to the petitioner. Consequently, the petitioner was unaware of the proceedings. The petitioner therefore could not appear before the customs authority. The petitioner was therefore not heard by the customs authority. In support of his contention that a repetition is maintainable even when a statutory alternative remedy is available, the learned advocate for the petitioner has relied upon 1986 4 Supreme Court cases, L.K. Ratna and others, Supreme Court, Whirlpool Corporation, Supreme Court, Rajbanslal Khania in versus India. Now, learned advocate for the customs has submitted that the petitioner was issued show cause notice at the address made available to the customs authority.
Yes.
Well, there. Well, so this order was under challenge. He has come before the report previously, did not raise this issue. Thereafter, he raised the issue of non-receipt of the chauffeurs. Thereafter, not being resident, being violative of national justice. This issue was. But at the time, he came before the rich court against this same order where penalty was imposed. That penalty, imposition of penalty was not a ground of violation of natural justice then. Now, my lord, we are in 2025. Now, he wants to reopen the case when he has preferred not to argue this before the rich court in the year 2060 against an order. Now, thereafter, my lord has already considered the defendant's order, my lord. And he has not challenged the body. Now, so what the crux of the case right now, this retribution is, my humble submission, this retribution is not at all maintainable at this stage, because the petitioner has failed to satisfy this court that there has been any violation of natural justice in any way whatsoever. And whatever point has been argued, has been tested once and has been preferred not to be as a violation of natural justice in the way. So all the things have been tested and tried, and petitioner is not such. So far as the writ petitioner is concerned, this writ petitioner is very well involved in the misdeclaration. What is the case? That the case is of misdeclaration. The case is after being involved in the misdeclaration, he chose to show his citizenship of a different country, whereas his address to which license he has been operating, has been as an Indian resident, and all the details was of an Indian resident. Now he could not deny this in the reach court. Manoj, may I place it once again, page 202. This has also been discussed. So he's tried that way also evasion. So this is a continuous case of trying to misdirect, trying to actually misguide this honorable court on some facts which are against him absolutely, which we had to prove again and again that how we are saying this, and there has been no violation of natural justice as of now. So kindly consider page 203 till 203 I have shown the last paragraph. 203, may I place? Institute of Chartered Accountants, Whirlpool Corporation and Harvanlal Sania are of the view that the recent jurisdiction is not outstepped by the availability of an alternative. It is a rule of discretion and not one of compulsion. In an appropriate case, in spite of availability of the alternative remedy, the High Court may still entertain the writ petition if such petition seeks to enforce any fundamental right where there is a failure of principles of natural justice or where the orders of proceeding are wholly without jurisdiction or the violation of an act is challenged. Here no violation is challenged. In the present case, the breach of principles of natural justice is that the petitioner claims to be residing in Malaysia. He claims to be a non-resident Indian. The petitioner has a local address in India. He is the residence of his father. He has disclosed such address in the transaction of the customs authorities. Apparently, the petitioner and his brother under the legal entity has entered into transactions which such transaction has ultimately been found to result in evasion of duty. It appears from the narration in the impugned order that the petitioner has made a voluntary statement under section 108 of the Customs Act before the customs authority. It also appears from such narration that the show cause notice to the petitioner was issued to the local address of the petitioner as known to the customs authorities. The petitioner claims to derive knowledge of the impugned order from a conversation that the petitioner claims to have had with his father at that local address. Apparently, the father of the petitioner had refused the impugned order. From the narration of the event as here, the irresistible conclusion is that the petitioner was served with a show at the local address given by the petitioner to the customs authority. It also appears that the petitioner was aware of the proceeding being undertaken by the customs authority. The fact that the petitioner and his brother has made voluntary statements to the petitioner, therefore being well aware of the proceeding, has chosen not to participate. The plea of the breach of principles of natural justice is therefore not a reason. The petitioner has not established that any fundamental right of the has been infringed by the customs authorities or that any of the grounds on which a petition is reasonable, despite availability of an alternative remedy, has happened, warranting the High Court interest. The impugned order is applicable under section 190 of the Customs Act. And then the repetition is this. So my humble submission is, it is clearly written that he did not pass. First, there has been an act of misdeclaration. The address that he has put in, he does not reside that. He doesn't operate any business. That he himself, as per him. But he did transaction. He did misdeclare from that address. He misutilized the entire without paying the custom duties, proper custom duties. Now, he tried to evade the government review. But thereafter, he did not participate in the adjudication proceedings. Thereafter, when the order was passed, he came before the writ court, alleging there has been a violation of natural justice. He participated in that writ petition in the court proceedings. Thereafter, he went to the division bench and actually defended this high amount of penalty, which was imposed on him in the year 2014, my lord. So that has also been tested. Now, my lord, suppose a condition that a resident who is now a resident of a different country pays the taxes and then does all the court proceedings and there is no violation of natural justice. there is alternative remedy available. He has knocked at all the doors, and all the doors he has found closed. Now he is trying to again reopen. How the duty will be that? That is one. And yes, on admission, on admission.
Declaration, 97 lakhs has been given.
So,
And appropriated in the audit of
so it is his admission that he has deposited some part of it. And clear the books, on his own admission. He has paid 50 lakhs, Milord. What is the transaction value? Here, the whole concentration of my humble direction. What is the transaction value? How do you make it? What is the discount? Apart from that, penalty is not a, it cannot equate with the penalty is penalty. So, the first hurdle before him, because when he comes to this court, on a court, he has to pass the hurdle of whether there have been any violation from whether the honorable Rich Court has any jurisdiction over the application. If the honorable court does not have any jurisdiction, then whatever be his prayer and petition, he would be with my heart. And he has not done the violence of the act. And I think the Milord has given him ample opportunity of considering a midway, but he insisted on it.
What about the Delhi High Court? Delhi High Court judgment?
It is different from this case. It is different.
Why?
Because this case, Milord, what happened in this? The order was against him, he went to Writ Court. He didn't go to tribunal, Milord, challenging that. Then he went to tribunal, then he went to the division bench, Milord. This entire situation of incident.
The Calcutta High Court judgment which he has given, you have seen this? You have given 2 copies. That's what Khairudin. But the company's demand in your case is not removed. That is pending. That is on. But I'll have to take into consideration the ground on which it was removed, and then that the matter is pending before. So that ground is not ground to. The company is not going to argue with innocence anymore, and I will say right. Because the last fact finding authority is the tribunal. The dispute, the lordship knows is of valuation. And appeals against the tribunal order relating to classification and valuation like on the people for the argument like they have exercised their right to appeal to both the department. Now, that appeal, is prima facie part by their own litigation policy, which describes that only matters of 3 crores or more can enter Supreme Court. The value of the demand of duty over there was 97 lakhs.
No, there is an exception.
There is no exception because the exception is to refund cases and 1 or 2 other cases not falling with regard to this. But then, if the original demand against the company itself has been set aside, then he has a case.
I have to take instruction there. I cannot.
Why it has been adjourned for so many days? You should have been because this
that part
that is his case in the writ petition also that it has been set aside. That is his case in the petition.
No, but I have to.
No, it's there. It's there in the writ petition. Even on the last occasion, there was a discussion on this. Yes, so
Instruction was sought by was there.
Monday. You can come back
Monday
with it.
This week or yes.
No, tomorrow I'll be other matters also.
Day after tomorrow.
1st December then. Buchanan, third learned advocate preparing for the respective parties substantially. Full stop. Same order. That matters, no? Where is your other side? Yes, yes. This in the name of a dead person.
And I also said that the initial when
I'm setting aside the assessment order, and it has to start afresh.
But only one thing, my lord, the petitioner, my lord, he give information to the assessing officer who is the legal heir. Because
Yes,
that
you
is
furnish that information because
that is the main difficulty.
how will they know how many legal heirs are there? How they will find out? Show me
This
that
is,
judgment.
my lord, absurd.
Show me. Where is that judgment? That you cannot have best of both the worlds. You will challenge and then you will inquire from whom? They are inquiring from you. They are inquiring from you. You tell the legal heirs. You will not tell the name of the legal heir. That is not done.
That is of the crux of the matter. My lord, both way, my lord, cut down the, my lord.
No, no. Where is the assessment order? One 770. এখানে this writ petition. insert them. Because unnecessarily I will not kill time, I will give any digit. Still, he had also referred to certain judgments. I will refer the judgments. When do you want? He seeks an accommodation. Learned advocate appearing for the petitioner seeks an accommodation, full stop, as requested. List this matter for further consideration on December 2, 2nd December 2, 2025. Mr. Day, in that matter where Mr. Chakraborty was appearing, I had written instructions in, I forgot to use the expression report. I have made it report in the order while correcting it. Because instructions you cannot file in court. Yes, so I had said that you will be. So that I have already incorporated as instructions only, but the next document that you'll be bringing will be in the form of a report. I have said that. And please ensure that all pages are signed by the authority because I am not taking on affidavit. So if a report is filed without affidavit, it should contain the signature of the person concerned because there will be no proof of authenticity of the pages, isn't it? If it is affirmed, the commissioner goes through it. But if it is a document coming from the authority and then I'm taking it on record, other pages are blank, it will be difficult. So if it contains signatures on all the pages, if it is true, all true, for all reports, at least I also ensured it when I was that side. So that should be there. In any report which is filed by an authority, all pages should be signed by that authority, unless it is a report in the form of an affidavit. Then it, yes, if two pages are replaced, then what will happen? Who will know which was the original, which was not? So he should take responsibility for what he writes. Yes. Yes. 1, 2, 3, 4.
Now, my lord, 140 me stated that there is of the department transaction with Reliance Resident Insurance Limited for 109 lakhs. I have entered into and on that basis, some attachment factors. Does not say what is the nature of that transaction and how income and income eligible factors. I provided this certain documents along with it. Matter of regarding information. It is given because matter of the case and it is information provided. As said, there are no specified documents again. General documents and it requires matter to stand up Reliance General Insurance. So that means the partner to take the course is Reliance General Insurance. And my transaction with Reliance General Insurance. Under general documents for option, I am provided with one dissemination report, my lord. The dissemination report does not mention my name anywhere. That the dissemination report will respect certain other group because my what department was after. I don't know that certain insurance company. I don't wanted to give permission to their agent. It was over and above what was prescribed by IRD. And they will bring it to some back channels and to certain other entities. Instead of taking permission, they would give it some other name and they would pay that commission. Now, my lord, dissemination report talks about that. They talk about certain transfer from other person, not even Reliance, some other person. And thereafter, and they does not mention my name anywhere. If my lord, they're referring to certain statement, again, my lord, my name is only on option, certain charts are provided. There is certain vendor name of Reliance Insurance. I'm one of their vendors. Either way, my lord, they can say that I am making payments to them, or my lord, I also receive payments from them. So my name will definitely be there as part of the vendor. And that is about it. There is no. But I finally replied to that. In my reply, I pointed it out that I am functioning under the control of the Ministry of Petroleum and Natural Gas. I'm subject to CAG order. CAG is giving me a certificate saying that there is no addition, there is no problem with my account. I also provide them with the details of my transactions with Reliance. As an insurer, as a travel agent, I provide them with the entire pickup, and I also provide them with details, and these details are pertaining to payments that I have made to Reliance. So that I'm collecting money from my customers on behalf of insurance, and I'm remitting it directly to my Reliance Insurance. I provide all those details. The department into the second notice. In the second notice, it says that you have not provided us with the details they are asking for. So I then I filed a second reply. In the second reply, this time I again repeat earlier about submission. There is no information in your potential that there is that I know that is talking undertaking. They want institutions given. I know that I think it's contrary to any kind of law. So it is asked to see any order from system and provide clear to further payment received from a line resident. So I have specified them holding charge. I have certain holdings. I my premises and so when I have various other holdings. I Reliance puts up with that. For that also I'm keeping certain things. So I provide the entire data of 1 crore 10 lakh. The allocation 1 crore 10 lakh. I don't know the department passes the 148 order. The 80 order, I don't have not considered it as that. We are not even talking about my transaction with Reliance. We are saying that Reliance has an intermediary called Prudent Insurance. We are saying that I have anything to transaction with Prudent. And that is my income chargeable to tax 50%. That was never the case, my lord. And secondly, my lord, I never got the opportunity and annexed a copy of the invoice. What was happening, your lordship, is Reliance was using invoices on me. When I was supposed to make a payment which I received from the customer, those invoices were being raised by Prudent on behalf of Reliance, and payments were being made directly to Reliance. I never had any transaction with Prudent. This entire allegation, I have a transaction with Prudent. That is also incorrect. So all along, the department has received under 148 without any information, and even the final decision being drawn is contrary to their own notices. And I don't have a transaction with.
No, but so far as this without information is concerned is a point that can be considered. But relationship with a particular entity will be a factual exercise, which at this stage may not be undertaken by the writ court, because that because that might require investigation into facts. Whether you have relationship or not will be a question of fact. Yes, information, whatever forms the basis of the notice, whether that qualifies for the definition of information in terms of the act or not is a legal question that can be tested. And if on that ground you succeed, you will be taking a jurisdictional ground on which the notice can be interfered with. But so far as the relationship ground is concerned, it will entail a factual inquiry, which writ court will be loath to undertake unless it is absolutely apparent from the records and there is no dispute at all. There can be no dispute, or maybe some kind of an assessment order of the department itself of previous years from where you can show that this is an admitted position and there cannot be a second opinion about this. Then in that case, yes, I can proceed as a writ court. But where there is a minimal scope of any factual inquiry, a writ court will stay its hands and say, no, let the proceedings continue. That is what. Right, but then
a statement of it. The reason given by the order was never that case. Either notices. So my relationship with this particular entity was so factual, that was never that case.
That can be a ground to indict a notice or an order if the order proceeds on a premise other than that which was put to you. Then in that case, you have a point of natural justice in the sense of not being able to, not being given an opportunity of answer the charge that has been leveled against you and on which you have been convicted ultimately. Pagination is not there. No, paragraph, no, you give me the paragraphs, that is better. Oh, that's right, it's taxman.com. So you give me the paragraphs. It doesn't match. No, not at all.
Paragraph 4.
4.
Section 140 issue derivative transaction of services. Yes, under the website, including all relevant documents for the procedure content 300 section 140 requires
because the facts of the case showed, that is what I said, it is apparent because you see this line, we say so because in the order dated 7th April 2022 in paragraph 4, assessing officer alleges that prima facie the appellant assessee has taken accommodation in pre by way of fund transfer from Mrs. Bright Moon Suppliers, which is a different company. So the allegation was not in respect of this company but was in respect of some other company, and therefore the court held that no, your information is this, notice is based on this information. So if reopening is not based on this information, now you say that no, against why you had taken loan. So if the information is of X, you have to stick to X and say that your case stands. If you stick to Y, you go. So that if that is the case, then in that case,
There's another aspect in this. First, the allegation was regarding derivative transaction, but subsequently it was an accommodation. So both are different. In the initial manner, the second one, that the appellant assessor has done 50 derivative transaction to
very well. But the division bench has gone on the difference of the entity.
Yes.
Yes. Same, I think same judgment has been given twice. What has happened in your case now? Page 80. Yes. Reliance General Insurance Company. Yes.
What is the transaction? How has income transaction nothing is mentioned. Why don't we take the next document with the page? This document is generated on a generated document like case related information. Why don't we see first in the middle page there is information details.
Yes.
The source pan and the source name is related to the line. Then I wrote document next subheading. Document file, specific document, no data available. Now there is therefore there is no specific document at all. In general document file, they are referring to Reliance General Insurance Company data zip code. I arranged all the documents. Next part, page 91. There is a dissemination. This dissemination report does not mention my name anywhere. Talks about how certain insurance companies are paying insurance, are paying commission in the line of some other company. And it does not mention my name anywhere. So the next document is at page 100. Verified department, which is pertaining to the search of one Ajay Mehta, with the dissemination report of the search of Ajay Mehta. Could never compare to be carried. Ajay Mehta is not known. And it is never of the department allocation.
Where is that name, Ajay Mehta?
I don't think it's page 100, right to the top below there.
My lord, can you come to page 98? It is clearly mentioned. 98.
But even at page the very top of starting of the dissemination report, page 91. 91. It says that search and seizure on middle layer business entities of insurance sector was conducted on 28th December 2020 by investigation unit under the name plan by Ajay Mehta. But page 91 mentions Ajay Mehta Group. Come to me. I have no transaction with this. Page 100 also has the part of the search report pertaining to the Ajay Mehta. It does not mention my name anywhere. Then I will page 128. statements are also a lot of people who are part of denying their insurance. They have not taken my name anywhere. However, I have a central government undertaking under the Minister of Petroleum. The thing that I will add conflict for facility provision and get money, how will it benefit us in any manner? I have a private property. From a private company. Then I don't, the only place where my name comes under the earlier, I don't know where they are provided all the vendors of the life insurance. I don't know details starts from I'll be 154.
Large marketing vendors. Yes. Yes, sir.
The figure of 1 crore 23 lakh, it is not even matching with the allegation of 1 crore.
No, what that is.
That is the figure. And I justify this figure of myself. And this is why, and then I don't make it my reply. These are all the details. Also, I will be 160. I don't make anything. 152 also I have again details of large marketing vendors. My name is there as one of the vendors. So regularly having some data does not apply to information. I file a reply at 165. Sorry, 190. We 165 to buy the in my I mentioned the nature of my transaction with the client. I state that my Bangalore lawyer facilitated air travel insurance for customer under a final scheme to present Reliance General Insurance Company covering both domestic and international travel. All insurance policies have been directly issued by Reliance General Insurance Company to the customer. Further, the Bangalore lawyer the corresponding insurance premiums given directly with Reliance General Insurance Company. And then I was at next page 194. I'm providing him with the details of payments made to Reliance General Insurance Company. And I'm giving him sample policies of the customer. And I'm also providing him with also I don't know 196. 197. And I'm providing him with all the details. And then I will take 190 and giving him sample copies of the insurance policy. I don't know 190. 190 is the name of the proposal in Bangalore at the top left hand corner of my head. But the name of the person of the insurance policy is one showing button. The policies are being issued directly to customers. Then I wrote the department issues a notice to me on 14th June 2025. That is page 221. Where is simply saying that there is a change to the incumbency. 221 and 820. So it says that there is a change to the incumbency. Next notice is matter of 323. These reports were replied dated 9th April 2025, submitted in response to the show cause notice dated 20th March 2025, were replied about correlate with the notice. Therefore, information is once again shared with you and you are requested to submit your reply within the date mentioned in the notice. Why don't he say that I have not understood? And he doesn't provide any document. I don't need if I doesn't provide anything that you want to be supposed to provide the first thing. I have the folder. I find a second difference. This time I was thinking that because here I have divided the data of all the payment transfer money going from me to Reliance General Insurance. It means that he is not, he feels I have not provided, I have not understood the correct purpose of the notice. So I provide data of money received from me from Reliance General Insurance. I was now see the nature of transaction with Reliance General Insurance.
Should we stop today? Almost 4:40. Tomorrow we'll continue because he will also have to answer. So, लिखें the petitioner assails and